last since then.
Oh, which year?
This year for admission purpose.
Oh, for first time it will be listed.
time.
Okay. When do you want? Friday?
7, 5.
So let's see, I beg to mention a matter pertaining to matter RSA of 2013. Matter will be posted for hearing on Thursday.
Hearing, we do not know. Is it at the stage of hearing?
This is long pending and it is taking time.
No, no. Is it at the stage of hearing? Then okay, we can have it. We can try it on Thursday. No problem.
But if I mentioned a civil division petition, it was last posted as motion item on 31st May. Unfortunately, due to my mother's illness,
Okay.
she was hospitalized. Adjournment was made, but Lordship.
Adjournment was for how
made
many?
Only for 1 day, but the order was passed after 2 weeks. Pray for listing the same.
2 weeks is over or not?
No, Lordship.
Then it will not be possible. It will amount to review of an order. We cannot do that.
Motion made.
You file an application, we'll review it. How can you pass an order which is against an order already passed? You file an application, 2-page application, that will be enough. We'll do it.
Lot.
Okay.
So let's say I beg to mention first April, 48 of the 23. So Friday will be
What is the stage?
admissible.
First April, what was the, it has not been admitted, 23 matter.
Admitted, but admission hearing.
After admission, is there any scope of admission hearing? What is the meaning of admission hearing? Yes, next.
May I please, your lordship? Your lordship, I beg to mention for listing of an RSA, your lordship, for hearing next week, any day.
RSA which year?
2018, your lordship.
18 matter. Hearing by mention memo will not be possible. What was the stage?
Your lordship, actually the judgment that has been stayed, your lordship.
What is the stage?
It's
In the High
hearing, your
Court?
lordship, for hearing.
Has it come for hearing earlier?
Yes, your lordship. It is, no, it was for orders, your lordship.
You
And
have
after
it for orders, we'll fix a date for hearing. By mention memo, we cannot have it for hearing.
Okay,
Have it for orders, we'll pass appropriate orders.
okay, your lordship. Lovely.
Yes,
Lordship, I beg to mention item 10.
10 years.
With consent of the other side, I pray for kickback.
You're for whom?
I'm for applicant.
Appellant.
Yes.
Madam Chaudhary, you are there?
Yes, sir.
Okay, you were
I was
earlier
there.
there. Okay, on a prayer made on behalf of the appellant. Matter is adjourned by 2 weeks. Mr. Sheikh has been informed?
Yes, yes.
Okay. Yes.
I pray for listing of an IA for withdrawal of 20% of the amount deposited by the insurance company.
Okay. Friday.
Right. And another matter, my lord, where the respondent has died. So we have filed one application delay.
What's up? Delay.
Substitution, delay, and
Yes, whenever you want fresh matters, we'll have it Friday.
Friday. Of life.
I'd like to make item 14 years old.
1-4.
Yes.
Yes.
There is to be the concept of kindly matter which is after to
Here for whom, madam?
respond.
Respondent.
Yes. I'm for the applicant also.
Here for the with Mr. Sayola.
Yes, sir.
Okay. Other side has been informed.
If the respondent time that
Okay, you're for the respondent. Okay, okay. Oh, you're making
Yes,
okay. Yes, madam, anything?
no, no.
When 2 weeks? Okay. On a prayer made on behalf of the respondent, list after 2 weeks. Yes. Which year?
2008. 2020, the convert by that
When it has not been, notice has not been issued?
delay has not been.
Has notice been issued?
Yes.
23 matter, we cannot,
For order, Solam, if service comes here or.
no, not this week.
Next week or.
Not this week. 23 matter next Wednesday. Okay.
Sure.
And this matter, 18 matter, 18 matter next
It
Tuesday.
is already in hearing for the.
Next Tuesday.
Apply.
With the consent of the respondent, I beg to mention item number 17. Lordship. Lordship, this matter is led by Sri Kiran Chaudhary, is out of.
The arbitration appeal.
Yes, Lordship.
Okay.
Lordship, kindly accommodate only for the
Yes, madam.
time for
Okay. We'll have it next Tuesday.
next Tuesday, not for Lordship. After it,
After a week, we'll say. On a prayer made on behalf of Sri K. N. Chaudhary, Learned Senior Counsel for the appellant, list after a week. Yes,
It is the lordship. Lordship with other side concerned, I beg to mention item number 6, lordship.
6 yes.
Lordship, due to personal difficulty of my senior, I am praying before your lordship to kindly adjourn the matter for
Who is
today.
the senior?
R.K. Moore, lord.
He's for the respondent.
Yes, your lordship.
Petitioner has been informed.
Lordship, other side has been, other side
Informed.
concerned has been,
Okay. On a prayer made on behalf of the respondent. Matter is adjourned by a week.
Lord.
17 matter, don't make a mention like this. 1 week.
highly obliged.
May it please your lord. Lordship, I beg to mention an item for listing, my lord. Second appeal, 2023 matter, but there's an injunction petition along. And it has to be come in the admission portal.
Injunction petition has notice been issued.
They have
That-
filed their objection,
Okay. You are praying for injunction.
injunction.
Okay, Friday.
Lordship, I pray for listing of a second appeal along with the two IAs, Lordship. The two IAs is pending.
I is for?
IAs for substitution and abatement. Lord. That RSA is of 2015, Lord.
Okay. Next Tuesday.
Obliged, Lord.
May I please, your lord? I beg to mention a listing of a civil division picture. It was last listed on January 2024.
Madam, you have it on Monday next. We have to pass orders on the abatement application, Monday next. Yes.
It was last listed in January 2024 for orders, Lordship.
Matter of which year?
23. In
Orders for what?
order for we are directed to take justice service and we have also filed affidavit, but thereafter it has never been
Okay, Monday next.
published.
Yes.
Lord, I beg to mention item 3 of Lordship, that is the matter as for the day. It is going undergoing approach with Hyderabad.
12 matter, madam.
Lordship, I am for responded 1 and 2. And if here the only thing is it has come after the 13th has come directly. So anyway, it's a medical issue. We are not objecting to that.
No, but medical issue, we may accommodate, but you have to make alternative arrangements, madam. For today, we'll accommodate you. 2012 matter, we are not adjourning. No way.
Your Lordship is going.
Understood,
Undergoing
we'll
an
accommodate you, but you make alternative arrangement. We cannot wait. Medical emergency, yes. We'll not have it today or tomorrow. But it cannot go like this. You know which is the year? 2024. 12 years. Case pending. We will not allow this. It is submitted that Sri T. Islam Learned Counsel for the appellant is undergoing treatment and therefore adjournment has been sought for. Full stop para. Considering the aforesaid ground. The aforesaid ground has been considered. Full stop. The appeal, however, is of the year 2012. Full stop. Considering all the above aspect, comma, a short accommodation is granted, directing listing of this matter for hearing on Tuesday next. Full stop. Appellants, if required, are to make alternative arrangements.
Your Lordship,
Next Tuesday.
Your Lordship, I beg to mention an FAO number 48 of 23. Your Lordship, the matter is in the admission column and answer has not been received yet. So the matter will be listed for any day. Friday.
Why?
Answer has been not received yet, and
What is the urgency of list mentioning this matter?
Your Lordship, the appellants are disturbing the peaceful process of the
Have you filed any injunction application?
No.
Then mentioning, what is the purpose of mentioning? For out of turn hearing. Make a case for out of turn hearing, will allow.
That's-
File an IA, will allow it.
Well,
Yes.
Please, Lordship. Lordship, with the consent of the appellant side,
Council, tie your buttons, not like this.
with the consent of the appellant side, I beg to mention item number 12.
12, yes.
Yes, the leading counsel in the case, Mr. S. Ali is unwell.
Okay.
So, Honor, I pray that this matter may be listed immediately.
Mr.
after
Ali is for the
application.
respondents.
Yes.
Viswas,
I
you are
have
for,
got it.
okay. We'll have it 23 matter. We'll have after 2 weeks.
Can we have it after the summer vacation? What date may be fixed?
Okay. It is submitted to Sri S. Ali Learned Counsel for the respondents. He is unwell and therefore a prayer for adjournment has been made. Full stop para. List after the summer vacations. Okay. 12.
May I-
My lord, Can a date be fixed? Like,
May I please, Your Honor? Item number 15, my senior is suffering from high fever. So let the matter listed
Who
after
is
2
the
weeks.
senior?
Amil Hussain.
High fever, election fever or what?
No, sir,
Actual temperature.
Excel.
It is submitted. No, a prayer for adjournment has been made on behalf of the. Why your writ petition before this court?
Yes.
Why is it before this court? Oh, you do? We are taking bench, civil bench one matter. Assign kora asani. Assign to kora thaibo nore. Anyone from education? It'll go before the appropriate bench, okay?
Okay.
Place this case before the appropriate bench. Or in bracket bench 2, civil bench 2. Even the next matter,
Next,
16, who is for 16? Anyone for 16, item 16? So, it will case. Just a minute. Take your day, like. Please before the appropriate bench, civil bench 2. 16 of quite even. It to education, no, isn't education it to 2 8 16 to. Oh, take this. Okay.
May I please?
Yes,
My lord, in RFA 27 of 2023, applicants are enjoying the step, my lord. So we have filed an objection, my lord, for respondent, my lord. So the matter may be listed
objection in what?
against the stay order, my.
Stay is in an IA.
Yes.
IA is pending.
Yes, ma'am.
Okay, next Monday.
I am ready for December 6th. CRP on IO on 6th.
Fresh matter. Fresh matter. When did you file?
4/5.
Okay, we'll have it on Friday. Friday.
Tomorrow, because this matter has been fixed by the Honorable Art Court beyond 6/6.
Okay, you have a prayer for stay.
This matter yesterday, Lord.
Okay. You have a prayer for stay. Okay, tomorrow we'll try. Yes, madam.
May this is your honor. I beg the mention for listing of first appeal order on 6th of
Fresh matter.
2023.
23 matter. Why do you want to listen?
Lordship, the matter has already been settled between the parties. So Lordship, kindly please the matter for withdrawal.
Withdrawal. Okay, we'll have it on day after tomorrow.
Right.
Your lordship. I beg to mention for listing RSA method 13.
RSA of which year?
2013.
13 matter. Okay, we'll have it.
Next Monday, Lord.
Okay, next Monday.
Much of that.
Have it for orders. We'll have immediately fix for hearing. By mention memo, we cannot fix for hearing. Okay.
2018 matter, your lordship granted time on 18th. Instead of 18th, can be on 19th, not 20th.
Which
2018 matter, I have.
you may change the date
Lordship.
when we
Your
when-
lordship has granted 18th. Can it be on 19th of 20? Already it is in the hearing column. District order said
you had made a mention today by mention
Yes.
memo. We change the date, no problem. I didn't want to talk about this. Yes, madam, what is this?
Lordship,
Sure.
this is against the judgment and decree dated 37/2007 passed in title appeal 26 of 2003, whereby the appeal was dismissed, affirming the judgment and decree dated 24/12/2002, passed in title suit 232 of 2000. Lordship.
Okay, who are you?
Lordship, I am the plaintiff. Lordship.
Appellant is the plaintiff.
Appellant.
Okay, just a minute.
Lordship, a similar case, it is a covered case. Lordship, a similar case has been dismissed. I will pass.
Yes, Madam Chaudhary,
I am for the
some other appeal has been dismissed.
Lordship. There are 3-4 appeals already dismissed, but
Madam is making a very fair submission. Is nothing to go about it.
very recently dismissed 160 of 2007. That is
Against the
not-
same judgment.
No, Lordship, in this case, what happened, there Guttu and Guttu company, their case is that they,
Guttu is the name of a company.
yes,
Yes,
We
sir.
thought it is the name of a boy.
no, Lordship, it's a company.
Guttu
Lordship.
and
Their case is
Why
that,
have you named Guttu?
Lordship,
It's a pet name. Guttu. Gutka company,
the company.
not
Tea
gutka.
No.
Guttu doesn't eat gutka.
Hmm.
He takes tea. You are the, just let us have the basic facts. Appellant is the plaintiff.
Yes, sir.
Play a suit for
Eviction. Lordship, kindly produce page number 13. the
no, just
title
tell us
judgment.
in basic facts. Suit for
Eviction, Lordship of the defendants.
suit for eviction. Then what had happened?
Lordship, we had purchased it from the Kalinagar Tea Estate in 1974, Lordship, by purchase deed.
You are a company.
Yes, Lordship. We are a registered partnership firm, Lordship. We became owner of this tea estate by purchase by deed.
No, Guttu and Company Private Limited. You are not a firm.
Lordship, that is the main issue, Lordship. It is a title suit, it is written that we are a partnership firm, Lordship. And that is was on this basis only the other judgment has been passed.
You are not a company.
Company, Lordship.
They are a company, but the purchase deed was in the name of
Name of
partnership
partnership
firm. So
Okay.
that was a rejection found in RSA
In-
160.
The purchase was in the name of a firm,
Firm, Lordship.
which was not existing. You were actually a company.
Company.
Oh, okay. Purchase of land from whom?
From the Kalinagar Tea Estate.
They are the defendants, no?
No, Lordship.
Tea estate. What is the name of the firm?
Sri Ram Tea Company.
Your name was Sri Ram Tea Company, the
We have
purchaser.
purchased it from them.
No, you purchased from Kalinagar Tea Estate.
Kalinagar Tea Estate by purchase deed by deed dated 13
Okay, who had
1974.
purchased?
We have purchased.
Name,
Guttu.
name.
Guttu and Company.
But you had described yourself as a firm.
Firm.
Okay. Then what had happened?
Lordship, the defendants have claimed that they have entered into an unregistered lease deed for a period of 99 years, and then they have taken possession of our land, more specifically Dag number 5, Lordship, of
Defendants.
the defendants against whom we have done the case. The predecessors have entered into a lease deed
And then defendant predecessors.
from the owner of the Kalinagar Tea Estate
Or they
in the year
claim,
1969.
claim of taking 99-year lease
99-year lease.
from the original vendor.
Yes, Lord.
That means Kalinagar.
Yes, Lord.
Then what happened?
Lordship, then they have taken possession of our land, Lordship.
Oh, okay.
Tag number
And
five. both also.
you had filed for eviction.
Lordship.
Then what has happened? Suit was dismissed.
Suit was dismissed. We have gone for appeal. That was also dismissed.
Also dismissed on the ground of locus.
Lordship dismissed on the ground.
Which date?
It was just, the judgment was 24 December 2002, Lordship.
Suit dismissed. And title appeal?
Title appeal was 26/2003. It was dismissed on 30/07/2007.
30?
7/2007.
30th of July 2007.
Lord.
Title appeal dismissed.
Lord.
Title appeal 26 of 2003.
Yes, sir.
Okay. Then you had come for
Come
this.
for a
Now what has happened to the other cases? Other cases, the
only one case we have, the recent one, RSA 160 of 2007.
Correct.
That is,
Hmm.
that is dismissed, Lord.
Now, what were the facts? Similar.
Similar fact.
What were the grounds of dismissal of the suit?
This ground, Lord,
See-
partnership firm and the company,
Was your locus statements doubted?
Lord.
Let us have a look at the judgment. This judgment is by which court? Okay. 100 something.
Lordship, Lordship, para 11.
Of the judgment?
Yes.
Please read.
The first substantial question of law. So formulated is as to whether the judgment of the courts before perverts to the facts of the case in comes to a finding that Exhibit 7, in this case it is Exhibit 1, is not specific because the numbers were not mentioned, although Exhibit 7 contains the thousand number and the account numbers of different plots of land, which clearly shows that the evidence purchased the entire Kalinagar estate and the suit that, in the opinion of this court, the said question of law cannot
The
be
same substantial questions of law has been framed here in this appeal.
Lordship, this Exhibit 1
No,
is
no.
their ownership deed,
Madam, in the appeal which you are considering,
Lordship.
what are the substantial questions of law? The same.
That is page 2, Lordship, whether the finding of the appellate court below is perverse to the facts of the
Yes,
case.
same.
Almost same.
Almost
Lordship.
Same. But don't you think that there were other substantial questions of law available to you?
As
These are
because
not substantial questions of
Lordship,
law.
only one ground which in the appeal also we
and
have said.
Lordship, till Supreme Court, Lordship, Supreme Court also discussed their appeal
Okay.
in another act. That I think finally up to Supreme Court. Lordship.
No, those were in the context of the substantial questions of law framed and answered.
Sorry.
Do you think these are substantial questions of law?
On this substantial question of law, the case was admitted as six, Lordship, 2008.
Madam, you had better substantial questions of law you could have framed. These are questions of fact. It connects, it has substance with the
But
the
look,
judgment
they are-
which is concerned, but you had other grounds.
The exhibit on which they are claiming their right title.
You have not
interest,
even
that is
taken the
fine.
ground of lifting of the veil. What is the purpose of the registered sale deed? What right is accrued to the vendor, to the purchaser? Was the sale deed challenged? It was not challenged. So, if the sale deed is still valid, you should have formulated the grounds, which you have not done. Okay. No point now. You're to D, madam?
Lordship,
A to D.
S.
S. Heard. Miss S to D. Learned Counsel for the appellant. Also heard. Miss R. Chaudhary. Learned Counsel for all the respondents.
Yeah.
All the respondents. Full stop. The instant appeal has been referred against a judgment and decree dated 30/7/2007 passed by the learned civil judge Karimganj in title appeal 26 of 2003, full stop. By the aforesaid judgment, comma, the judgment and decree dated 24/12/2002 passed by the learned civil judge within bracket junior division number 3, Karimganj in title suit number 232 of 2000 has been affirmed. Full stop. The appeal was admitted on the following substantial questions of law by the order dated 7/1/2008. 7/1/2008 court order पर सही तरह से full stop. The case projected by the appellant as plaintiff. No, the suit was instituted by the appellant as plaintiff
parties are praying for confirmation.
No, ঠিক আছে কেনে বন্ধ হয়েছে জানি ঠিক আছে declaration of title. Okay, then what had happened?
And for declaration that the document number 5342 of 1999 registered in Karimganj Sub-Registry Office purported to be executed by Srimati Shanti Bala Das and Onima Bala Das in favor of Virendra Kumar Das, and the document number 484 of 2000 executed by Virendra Kumar Das in favor of Mohammad Alauddin, that is plaintiff lordship.
Still did.
Yes, lordship. And document number 485 of 2000.
Those documents are sealed deeds or what?
Sale deeds, lordship, registered sale
They
deeds.
have challenged the sale deeds.
They have said
Okay,
executed by say Virendra Kumar Das.
okay,
in
okay, we
favor
have
of
understood. Then what had
lordship.
happened?
Those are, that is their contract type. Lordship. Then lordship, suit was dismissed, lordship.
You adduced evidence,
Yes, sir.
both parties.
Yes, sir.
Suit
decreed, lordship.
Madam, just broadly tell us what is the issue involved?
Lordship, my question, during preparation of this regular second debate, I found that lordship, first appellate court held that as I have submitted the certified copy of the sale deed, originals I have not submitted. So my suit was dismissed. Counterclaim part will not come as because they have not preferred any appeal against dismissal of counterclaim.
Counterclaim is also dismissed.
Yes, Lord.
Okay.
So that part will not come in this regular second appeal. My second appeal will be
Now,
on
what had happened to the first appellate stage?
first appellate lordship. My suit was first decreed, counterclaim dismissed.
Okay.
So they have
Oh, appellate
preferred,
court had,
yes,
okay,
They have
allowed
preferred
allowed their
one
appeal.
yes, but
And
only
dismissed
one
your
second
suit.
appeal.
The first appellate court had dismissed your suit.
Yes.
Okay.
So I am lordship relying on my sale deeds. I am paying cited interest and lordship confirmation of position. While preparation of the lordship regular second appeal for hearing, I came to know that the originals were not submitted. Then I inquired with the client lordship. He informed me that originals were lordship taken from the sub-registry office later on, and those were kept at his home. So originals are lying with him. Then I called him lordship and prepared an IA for submission of those original sale deeds as an additional evidence. And your lordship is aware, as per Union of India and Ibrahim lordship, the additional evidence the additional evidence prayer may not be rejected. It should be considered at the time of lordship hearing, as per paragraph 52. May I read? Thus, from the above.
No,
it is-
your application, was it before the first appellate court?
No, Lord.
4127. You are
No,
making it here
Yes, Lord.
in the
Even
second
lordship-
appeal.
Yes, lordship. Even
Second
Supreme-
appeal, we are only considering substantial questions of law.
No, lordship.
Are
there
we
is-
here to adduce, allow or adjudicate the issue? Whether we should,
Okay.
as a second appellate court,
Lordship, first, I am not arguing the points that a certified copy of sale deed can be taken into consideration, as because I have already filed an IA for lordship additional evidence. If your lordship satisfied on additional evidence, then your lordship will demand it back for taking additional
Madam,
evidence.
see, we are in a second appellate stage.
Lordship, in second appellate.
You know
stage
very
also-
well our limitations. Had it been a first appeal, we would have ourselves gone into the aspect whether this evidence can be taken into account, and if required, we either have the evidence in this court, or we, for convenience purpose, we remand it back.
Lordship.
Have the evidence recorded in the lower
Lordship,
court.
in the second appeal stage also, it can be remanded. There is a decision of lordship 2016 AIR
Let us-
Guwahati 172. Lordship. In that case, I was representing the respondents and Mr. Andhar was representing the appellants, lordship. In that case also, at the time of second appeal hearing, lordship, the IA was filed. Para 14, your lordship, page 6.
The circumstance was different, madam. You
Okay,
read
that was-
paragraph 10.
Lordship, that was kept in the record, but it was not exhibited. Even then, Lordship.
It was
they were
not
given-
marked as exhibit.
In my case, Lordship, certified copies I have already exhibited, I have proved, Lordship. Only the originals are lying with the plaintiff.
You know what is to be done, what was to be done.
Lordship, only my prayer before your Lordship, if your Lordship allow my order 41 rule 27 petition, Lordship, your Lordship can remand it to the learned first appellate court, and thereafter, Lordship, taking into consideration this.
Do we have a
procedural-
scope? We are not appreciating evidence.
No, Lordship, maybe first appellate court or trial court take into consideration the additional evidences. Order 41 rule 27, Lordship. state. As Lordship, we cannot prove those original documents before this court.
No, you knew what was there to be done. Even if the originals were not with you.
Lord.
Worst case, it was not, you knew, there is a recourse, you know what to do.
Already, Lordship, certified copies were already produced.
Now,
before the-
certified copy will it do? What should be done then?
And Lordship, there is a presumption of certified copy of a registered document. Lordship.
Those are not
Yeah.
issues before us.
Lord.
You are correct. 74, I think. What
Lord.
is it? 74 or what?
Evidence Act 74.
Yes, 74, I think, yes.
Yep. '79.
79.
Yes. Order 41, rule 27, Your Lordship, for a moment.
Let us see.
Production of additional evidence in appellate court.
See, that is an exception.
Right.
And there are conditions that in, even after exercise of due diligence.
Right.
That is not the thing. Yeah, otherwise also it will not be applicable. It's not a routine exercise of powers.
Lordship, that is true, Lordship, but already the certified copies are exhibited. There is no lacuna or there
See,
is no due diligence.
the
on
parties
part-
in an appeal shall not be entitled to produce additional evidence either ordered or, this is a bar, but the exception has been carved out
Yes,
in 27. The court from whose decree the appeal is preferred has refused to admit evidence which ought to have admitted. This is not
Lord,
your case.
that is not my.
Number two, party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within the knowledge. You fulfill any of the condition?
Or
Finish.
Lordship, or could not after the exercise of due
Due diligence.
diligence be produced by him at the time when the decree
Yes.
appealed against one.
Yes.
So Lordship, those were lying in the sub-registry office, Lordship. So it was not advised that,
That is not
and
due
there
diligence.
is Lordship,
What is the
no,
meaning of due diligence?
Lordship, there was no objection
No,
at all. raised.
apart from the fact that these are not questions which have to be decided here,
Lord.
even assuming that this was a question, suppose this was an application which you raised before the first appellate court,
Lord.
rejected, you come up in second appeal and raise one of this as issue as a substantial issue.
Lord.
We may decide, but that occasion has not arisen. You have filed for the first time an independent application under 4127.
Lord.
Let us go to the aspect that even that aspect will consider as an appellate court. How much powers we have as a second appellate court, that's a different aspect. But taking a very liberal view, you do not meet the requirements of 4127.
But Lordship, the appellate court, if requires any document to be produced or any witness to be examined to enable it to pronounce judgment, Lordship.
Or for any other substantive issue, first the appellate court has to, we have to require, we are not examining that aspect.
Lord. For that
Mm.
only I am not praying, as already the certified copies are there as exhibited, Lordship. And it is a case of the defendant that, Lordship, they have purchased, but they
No,
cannot.
madam,
prove that.
if you read
It-
4127 carefully,
Lord.
the understanding which we generally have, that's a liberal kind of a provision for the appellate court. It's not like that. It is actually a bar. Appellate court should not allow adducing of evidence at that stage independently. And only on certain exceptional circumstances, it has been given only to ensure that justice is met, ends of justice are met. Now here, due diligence is not there. And we are not exercising so much of powers to call for the.
Today, Lordship, Second appeal, I have prepared only on the basis of this IA lordship. As if your lordship wants to hear the appeal
We are
on
hearing.
lordship on merit lordship, then your lordship give some more time. to
No.
Thursday, I'll prepare. As because lordship
No, no more
already
time.
certified copies.
No more time. 2009 to 2024 is
lordship,
more than
any
more time.
date
No,
on this
sorry,
week, lordship.
sorry.
Lordship,
Not even,
otherwise,
not even 1 hour's adjournment. We are hearing this matter.
lordship, I am only on the IA.
We do not know.
lordship.
It's
But
up to you.
In this case, lordship, the defendant could not produce their right title interest and plaintiff produced his suit was decreed by the learned trial court
On the basis of what?
on the basis of registered sale list certified copies. Lord. At that point of time, the originals were not with him. Lord. Whether the leave was taken from the court or not, that
You know, you have answered.
Lord, that I have
You
no
answered.
idea.
You
I
have
have to go
answered.
through the
The question
order.
which we were to put, you know the question, you have
Right.
answered. And fairly, there is a procedure laid down. If you do not have the original, you know what to do.
Right.
A demand for a copy, if not given, take leave, direct the originals to be
For
produced.
that lordship, I
Take
have
some
to go
evidence
through the LCR and the order sheet, whether any leave was taken or not.
The judgment does not reflect.
Lord.
evidence.
But only the thing is that the copies when they have exhibited lordship, there was no objection raised by the other side lordship. Defendant did not objected to the exhibit.
So what was the first appeal for?
And it was
What was the first appeal for? What were the grounds in the first appeal? That was the ground.
in that case, lordship, if sometime day after tomorrow or lordship, as lordship, I was preparing that. case.
We are closing this. You are free to make your arguments.
Lordship, any date and Thursday, lordship,
No, no,
part third, lordship.
no parted. 2009 matter, no parted.
Then, lordship.
You address on the substantial question of law. Substantial question of law was on a very, very narrow campus
110, lordship.
on 41 rule 31.
Lord. Page 13, lordship. Decisions and reasons thereof. The main grounds stated in a memorandum of appeal are that the impugned judgment and decree is vitiated for violation of principles of natural justice. For the reasons that the judgment and decree was passed without giving opportunity of adducing evidence to the defendant that the appellant defendant was hospitalized and therefore he could not proceed with the case during the period and the suit was decided ex parte. That the plaintiffs are stopped by waiver and acquiescence in strict claim of title over the suit land, which has become a public place of worship for a period beyond the period of limitation. And the plaintiffs having failed to adduce any evidence to establish their title by nullifying the said assertion of the defendant. So they are in one sense, lordship, they are saying adverse possession. Adverse possession means they are admitting my title. This aspect of matter ought to have been scrutinized more stringently in as much as the suit had proceeded ex parte that errors have been committed in shifting the burden of the defendant in deciding the case and that the facts and circumstances disclose that the matter needs to be decided on merit and not ex parte. It has been revealed in the impugned judgment that cross-examination of witness for the plaintiff side was adjourned on many occasions on the prayer of either side, and since 24/9/2003, the defendant remained absent without any step. So that even not cross-examine the plaintiff's witness. Ultimately, the cross-examination of PW 1 and 2 by defendant side was forfeited as per order dated 1/11/2003. On subsequent dates also, the defendant remained absent. Thereafter, the suit was posted for judgment after hearing argument of the plaintiff side. On going through the record, it transpires that the defendant filed written statement with counterclaim on 14/3/2002, upon which the plaintiffs filed written statement against counterclaim on 3/5/2002. On 9/1/2003, issues were framed after taking several adjournments from 14/2/2003 to 11/6/2003. Evidence of affidavit was filed by the plaintiff side on 9/7/2003. The defendant side took adjournment on 29/7/2003. Thereafter, on 8/9/2003, the plaintiff side filed evidence of another witness. On said date also, the defendant side took adjournment of hearing. Date was fixed for cross-examination of witness number 1 for the plaintiff side also. Thereafter, on 24/9/2003, the defendant remained absent and the plaintiff side also prayed for adjournment of hearing. On 3/11/2003, the plaintiff was present with his witness, but the defendant remained absent without any step. On said date, 3/11/2003, the cross-examination of PW 1 and 2 by the defendant side was forfeited, and next date was fixed for evidence of defendant side, if any, as the plaintiff side declined to adduce any further evidence. The appellant side has drawn attention to the decision of Honorable Guwahati High Court in 2008-1 DLR 465 in the case of Prasanto Kumar Kakatoni and others versus Tuniram Katoni and others, in which it was held that though under Order 17 Rule 1, not more than 3 adjournments can be granted to a party during the hearing of a suit, the fact remains that this is the requirement of procedural law. It therefore, on good and justified reasons, if a plaintiff has obtained 3 adjournments or more than 3, this alone cannot be made an absolute ground to refuse the adjournment of hearing of the suit if on the date when the plaintiff applies for adjournment, he has been able to make out a good case for his inability to either produce his witness or offer himself for cross-examination. The period of hospitalization in the year 2002 as averred in the memorandum of appeal was prior to framing of issues, and the period of hospitalization for the period from 5/11/3 to 17/11/3 as averred in the memorandum of appeal is also subsequent to the date on which the defendant remained absent. The date fixed for cross-examination of witnesses for plaintiffs. The period of hospitalization, obviously, even if accepted as true, will not have any effect on the matter of forfeiture of cross-examination. The defendant remained absent without step, no cause was shown or steps taken. The decision of Honorable Guwahati High Court will not help the absent. The plaintiffs have claimed declaration of right title interest and confirmation of possession based upon certain facts in the plaint, which the plaintiffs are to prove in order to succeed to obtain decree. Cause of action is independent of defense taken. Obviously, there is cause of action for the suit. Learned Court below has rightly decided the issue number 1. Issue number 2, Learned Court below has come to the conclusion that the defendants have alleged that the suit was required to be filed under Order 1 Rule 8, yet they failed to disclose materials in support of the allegation. The suit was filed in the individual capacity, and therefore there was nothing on record to show that suit was bad for not impleading necessary parties, but it transpires on perusal of written statement that the defendants have averred in para 4 of written statement that the suit is bad for defect of parties for not impleading the state of Assam, all legal heirs of Bipin Bihari Das, Vinod Bihari Das, and the legal heirs of Abdul Chopur. The instant suit is for decree for declaration of right, title, and interest, confirmation of position, and permanent injunction. In a suit of this nature, state of Assam is not a necessary party. The defendants have not named the legal heirs of Bipin Bihari Das, Vinod Bihari Das, and Abdul Chopur, not arrayed as parties to the suit. The assertion of the defendants has not been substantiated. Finding the Learned Court below on issue number 2 needs no interference. Issue number 3, the plaintiffs have claimed right title interest over the suit then on the strength of purchase deed number so, through which the plaintiffs and their brother Abdul Chopur purchased 3 plots of land from Virendra Kumar Das. Possession was delivered to the purchasers by said Virendra Kumar Das PW1. Mohammad Alauddin has stated in his evidence on affidavit that exhibits 2 and 3 respectively are the certified copies of said deeds. The purchase was for consideration of rupees 30,000 for each. the vendor Virendra Kumar Das and his two sisters, namely Santi Bala Das and Anima Bala Das, inherited suit land from their father, Bipin Bihari Das. PW1 has further stated that the vendor purchased the shares of his two sisters through sale deed number 5342 dated 20. Exhibit 1 is the certified copy of said deed. By the purchase, he became absolute owner and possessor of the suit land, and the suit land was sold to the plaintiff and Abdul Sabur by Exhibits 2, 3, and 4. Through registered deed number 1350 of 2000. The plaintiff brothers purchased the share of Pritilal Das, son of pre-deceased sister of vendor Virendra Kumar Das, who claimed his share in the suit land. Exhibit 5 is certified copy of said deed. Exhibit 6 is certified copy of final khatiyan collected by the plaintiff. Exhibit 7 is certified copy of information issued by settlement officer to the effect that, as per records, Virendra Kumar Das was the owner. Through Exhibits 8.1 and 8.4, Talan's revenue in respect of the suit land was paid. Abdul Sabur died unmarried, and the plaintiffs became absolute owner of the suit land as successors to Abdul Sabur, the brother of the plaintiff. PW1 has further stated that their neighbor, the defendant, threatened them and instituted false case Karimganj PS case number so, which resulted in submission of final report. Exhibit 9 is the certified copy of final report. Proceedings under section 107 and 144 CRPC were also initiated against the plaintiff. The proceedings were dropped. Exhibit 10 is certified copy of complaint of aforementioned PS case number so. Exhibit 11 is the certified copy of order passed in proceeding under section 107 CRPC. PW2 Muhammad Sarkam Ali has stated in his evidence on affidavit that Virendra Kumar Das was in full possession of her suit land. He planted crops, coconut, betelnut trees. He delivered possession to the plaintiff and Abdul Sabur. The plaintiff had a kacha bamboo house in the western side. Eastern side is low-lying land used for fishing. They grew vegetables in the rest portion. The first question to be determined is whether the purchase deeds are duly proved or not. Certified copies of purchase deeds have been filed. The deeds in question are not old deeds. Section 64 of the Indian Evidence Act provides that documents must be proved by primary evidence, except in cases in which secondary evidence is permissible under Section 65 of the said Act. The section mentions 7 cases in which secondary evidence is admissible when the original is in possession or power of the opposite party or of a person who is out of the reach of or of subject to the process of the court, or of any person legally bound to produce it, and when such person legally bound to produce it, and when such person does not produce it after demand, that is notice under Section 66. When the existence, condition, or contents of the original are admitted in writing by the person against whom it is proved, when the original is lost or destroyed, when the production is physically impossible or highly inconvenient, when the original is a public document, when the original is one of which certified copy is permitted by this Act, when the originals consist of numerous accounts or other documents which cannot be conveniently examined in court. If the original document is lost, destroyed, detained by the opponent or third person who does not produce it after notice or is physically irremovable, secondary evidence is admissible. In the instant case, Section 65F is relevant. Contents and execution of documents are to be proved. Registration of a document is no proof of execution. Admission of execution before registrar is not enough. AIR 1979, Guwahati 68, where written documents exist, they have to be produced as being the best evidence of contents of the document. When a certified copy of a document is produced, there is no presumption as to the genuineness or execution of the document. So far as execution of a document is concerned, it must be proved according to law. The defendant has challenged the documents and burden to prove the execution of the documents is very heavy upon the plaintiff, but the plaintiffs have merely produced the certified copies of purchase deeds which have been marked as exhibits. Honorable Guwahati High Court in PGD Ombrain and others versus Collector of Kamrup Guwahati and another has held as reported in AR 1980 Guwahati 55 that mere marking of a document as exhibit does not dispense with the proof of the document. In order to prove purchase deeds, primary evidence must be produced so long the deeds exist and proof complying with Section 67 of the Indian Evidence Act as regards signature and handwriting of person alleged to have signed or written the document is necessary. In view of above, it is concluded that the certified copies of purchase deeds cannot be taken as proof of execution of said purchase deeds. And court below has committed an error in arriving at the conclusion that the documents had duly been executed as because the deeds were registered. The plaintiffs have claimed that they have been in possession over the suit land since delivery of the possession to them by the vendor Birendra Kumar Das. As discussed already, the purchase deeds have not been proved duly as regards delivery of possession by Birendra Kumar Das. There is no frozen evidence. Mere statement that the possession was so delivered will not amount to proof. As such, it is concluded that the plaintiffs have failed to prove that they have been possessing the suit land by virtue of their purchase. Issue number 3 is accordingly answered in the negative and decided against the plaintiff. On the basis of findings on issue number 3, it is concluded that the plaintiffs are not entitled to get a degree as straightforward. Issue number 5, the defendant has raised counterclaim contending in the written statement that the suit land was bequeathed by Bipin Bihari Das and Vinod Bihari Das was entrusted with the power to look after the temple of Mother Goddess Kali. The temple of Mother Goddess Kali and the tank are situated on the suit land. The defendant has also challenged the purchase deeds relied upon the plaintiffs. Counterclaim is independent of offense taken by the plaintiffs against the counterclaim. The defendant is to prove the counterclaim and the counterclaim has properly been raised in written state. Obviously, there is cause of action for the counterclaim. This issue is answered in the affirmative and decided in favor of the defendant. I am not reading the other parts because the counterclaim was
Yes, dismissed.
and there was no appeal before this court. So on this finding, Lordship, the suit of the plaintiff was Lordship when there was no objection and when the originals are lying in the sub-registry office, the plaintiff has submitted the
But their basic defense was that the vendor, your vendor,
Lord,
Birendra Das, he did
Right.
not have any alienable interest over the suit land.
Right.
It was already bequeathed in the name of the idol, the devoter.
no, Lordship, they could not prove that they have not adduced any evidence. Only pleading will not entitle them for different. Lordship. There was no evidence
No,
by the
no, we are not on the counterclaim.
Lord.
We are only adjudicating your claim
Right.
and their defense.
Right.
They had taken a defense that Birendra Das
Right.
did not have any alienable interest, which could have been transferred.
Right.
Now you are banking upon a sale deed.
Right.
That this is, and that sale deed per se is not the.
My vendor sale deed is exhibit 1. And my purchase deeds are 2, 3, 4. We both brothers purchased from Birendra
So
Kumar.
your vendor was not the plaintiff.
No, my vendor was not the plaintiff. I am the
So
plaintiff.
your right has accrued from the deeds which are in your name.
Yes.
It is those deeds which would be the subject matter of scrutiny by the court.
Right.
And those deeds have been found to be only certified copies, the originals are not exhibited.
Right.
And the court perhaps has rightly said that mere markings may not dispense with the requirement of
Lordship,
proof.
They remain silent. They have not even cross-examined the PW's Lordship. If there is no cross-examination by the other side to the evidence in chief of the plaintiff, Lordship, the evidence in chief will remain in Lordship. My evidence was never
Evidence and
questioned,
things will remain open for consideration.
Lord. My evidence
See,
was never
even
questioned.
the Nasim Bano case,
Lord.
that non-rebuttal with amount to admission, that has been explained. Non-rebuttal by not filing an affidavit in opposition in a proceeding.
But Lordship, from
It
their
be
pleading,
open for consideration. It cannot be taken as a gospel
Lord,
truth.
I am
And
saying that the
everything
court
has
has
to be done
power.
in accordance with law. If something absurd has been written in an pleadings,
Lord.
only because it's not rebuttal, will it be accepted by the court?
But
Court
Lordship,
will definitely consider, yes, this is the
in fact,
statement.
Lordship, they have admitted my title, Lord. When they are saying they are in adverse possession, that means, Lordship, to the true owner's title, they are adversely possessing the suit. It is their case, Lordship. So that means, Lordship, they are admitting plaintiff's title.
Let us see that part. What was adverse position one of the issues? That was not even the issue.
No, Lord. Their written statement, page 48, Lord.
4.8.
48. Para 9, I have written, page 49. That the
49. Yes.
Page for the answering defendant does not admit any of the averments of para 1, 2, and 3 of the plaint as true and correct. The plaintiffs have got no right title and possession into the suit land. As such, there is no reason for filing of the suit, and so also there is no reason for granting of injunction. Virendra Kumar Das or any of the legal heirs of late Bipin Bihari Das have no alienable interest over the suit land. Late Bipin Bihari Das of village Narikoli bequeathed the suit properties in favor of idol Kalimata, and late Vinod Bihari Das, father of the answering defendant, was entrusted with the power to manage the suit devoted property by executing a deed on 14 Kartik 1374 Bangladesh. And while the state Vinod Bihari Das was possessing the suit land by constructing an Kacha Kali Mandir as a religious public institution, died leaving behind his son, the answering defendant, and the others. And after death of Vinod Bihari Das, the answering defendant, as per terms of the said deed of bequest, has been possession and managing the said land and the Kalibari public containing to offer puja. The general public offer same continuing to offer puja and performing religious functions into the suit land since the year 1374 Bangladesh without any interruption, peacefully and adversely to all others. So there is a pleading that adversely to all others. They are admitting that, Lordship, my vendor's father is the owner of the suit network.
Where?
The Bipin Bihari, my vendor's father. Lord.
Yes. Vendor's father, yes.
Yes, but this original owner is Bipin Bihari Das.
Understood.
His son is Virendra Kumar Das.
Correct.
He has purchased through Exhibit 1 all the shares of his
Sisters.
Lord. And thereafter he became.
There was also a claim of one of the sons of the sisters,
Yes, Lordship.
Paritimal or something.
And later on, the Exhibit 5, Lordship, that interest was also purchased by the plaintiff when he claimed his mother's share.
This may not be enough because it's only a narration of facts in the chronological narration.
No,
Yes, given.
they are pleading two types of pleading, Lordship. They are taking two pleadings, one by purchase, bequeathed, and one by adverse possession.
No. And since then, this use of this expression adversely to all others, yes, you may contend, but that is not, it's a narration of the chronology.
No,
How the land in question was bequeathed for a
as per
debitor.
terms
For a
of the
debitor,
state deed of
debitor was to be managed by Bipin. Bipin passed away.
Lord.
Thereafter, you claim that you purchased from Biren.
Yes, from
Okay.
Bipin's
Now,
son.
yes, now Bipin's son, Biren.
Lord.
Now the case of the defendant is that Biren did not even have an alienable interest. It was in the name of the debitor.
So that deed was not Lordship exhibited. There was no evidence, only his pleading.
So to have a decree in your favor, You
Lordship.
have to establish your right on the
Yes,
basis of documents.
How Bipin, Lordship, Vinod became owner, I have proved, Lordship.
How you have become the owner from
I
Binod?
have, Lordship,
Yeah.
exhibited, Lordship, 2, 3, 4, and 5, all the deeds I have exhibited. Lordship.
Certified copies.
Yes, Lordship, there was no objection raised by them, Lordship, in exhibiting. And Lordship, when there is a two pleading, it is also settled that defendant cannot take two pleading.
Why defend wavering rights? You can, as a defendant, you can take any pleading.
Lordship, but
Plaintiff, you have to be consistent.
Lordship, but
That is
bequest,
not the law, madam. Your stand can be wavering. You can take this stand, you can take that stand. You are a defendant.
if they are taking the pleading of
As a
adverse
plaintiff, you have to be consistent. You cannot change your stand.
Lordship.
Defendant,
But
it's
if,
free.
Lordship, they are taking a stand that they are in adverse position, Lordship, that means we are owner, Lordship. Adversely to others, they have
Was
specifically,
there any issue on adverse position?
no, Lordship, there
There-
was no issue.
There was no issue on adverse position.
And issues are, Lordship, see, because of that, Lordship, the issues page 33, Lordship,
33.
33. Trial court judgment. Is there any cause of action for the suit? Is the suit paid for necessary parties? Whether the plaintiffs have right, title, interest, and position over the suit land by virtue of their purchase? Whether the plaintiffs are entitled to get a decree as prayed for? Is there any cause of action for the counterclaim? Is the suit land a devotor property, namely Narikoli, Sarbojanin, Kalibari, bequeathed by original owner Bipin Bihari Das? To what relief and relief the defendants are entitled?
Okay. And the discussions, we are
Discuss-
concerned with mainly with 3 and 4.
Yes, sir. Three, Lordship.
Because 4 counterclaim has been rejected.
Three, whether the plaintiffs have right, title, interest, and
Yes.
possession over the suit land. That is the main issue, Lordship. Annex page 34, last paragraph.
Yes, yes.
It is not disputed that Bipin Bihari Das was the original owner of the suit land. It is also not disputed that Virendra Kumar Das and his sisters Santibala and Omiyabala are the legal heirs of late Bipin Bihari Das.
Mm.
Plaintiff contended that sisters of Virendra sold out their share to Virendra, their vendor, by the Exhibit 5 sale deed in the year 1999, and then Virendra sold out the suit land to the plaintiffs and their brother Abdul Sabur by the Exhibit 1, 2, and 3 sale deeds. It further appears from Exhibit 6 that the suit land in fact stood in the name of Bipin Das, father of Virendra, vendor of plaintiffs. On the other hand, defendant though contended that the suit land was bequeathed by Bipin Das by a document, but in course of hearing, the defendant opted to remain absent and did not
Let us see the discussion by the appellate court in issue number 3.
page 17.
17.
Regarding purchase deeds, I just read out that issue number 2. First appellate court held that these were certified copies, so no right title can be declared to the I read issue number 6 of page 35 of trial court judgment. We already discussed in foregoing issue number 3 that a chronology cannot be accepted as a proof of bequest. All sorts of gift shall be effected only by registered deed. Besides, as we
Madam
observe,
Chaudhary, we are not going to the legality of the judgment by which the counterclaim has been dismissed. That is not the part of challenge.
Sure.
So whether they have right or not, we are not going to adjudicate.
Sure.
We are only
Only that.
adjudicating your assertion.
so issue number 3 and issue number 4 are for the
Claims that
plaintiff.
they have been in position over the suit.
And issue number 4, trial courts held that in view of my decision given in issue number 3, plaintiffs are entitled to get a decree as prayed for. Issue number 3, trial court held that
Yes, yes, what do you say?
The landed applicant could rightly pass the judgment of it. During the course of the trial, they produced the certificate copy of the documents because the registration of a document does not prove the execution of it. And then regarding their order 49/27 petition, they pointed that in the paragraph.
Now, first you address on the main issue, then we'll go to
Lordship,
4127.
yes, Lordship, actually the Bipin Behari is that is the owner of the suit land. And the-
Go slow a bit, Bipin Bihari is the owner,
Yes. And
was the owner.
Yes.
Then,
then he bequeathed the property in favor of the idol of Kali Mata, and late Vinod Behari, the father of the answer defendant, he was entrusted to look after the management of the Kali Mata, and he was possessing this since 1374 years.
who was entrusted? Biren.
Vinod Behari Das.
Bipin had entrusted his son.
Yes, father of the answering.
Answering defendant is Binod.
Yes.
Biren.
Vinod
Biren,
Behari.
no,
Vinod
Biren.
Behari Das. Bipin Behari, my case is that Bipin,
Bipin, who is the son of Bipin?
Vinod Behari Das is the son of the Bipin.
That is it, Binod. He entrusted to Binod then.
Yes. Bipin Behari entrusted the Vinod Behari Das to look after and management and affair of the
Entrusted.
Lord Kali temple, Kali Mata temple.
Yes.
And then it was since that time he was possessing the same since 14 day of Kartik, that is
Okay, that we have noted. Then who is Biren? Biren is the son of Binod. Present defendant.
now present defendant is the
They are whom? They are son of?
son of Vinod Behari Das.
Who is Biren then?
Biren Behari is the
Brother.
actually the
What is the name of the father of Biren Das?
none of the actually they have claimed that Bipin Chandra Das.
No, all along they have been saying that they purchased from Birendra Kumar Das. Who is Birendra Kumar Das?
son of Bipin.
Another son of Bipin Bihari.
No, only one son.
But they said that it was given to Binod Bihari
Yes.
to entrust, he was entrusted to look after the property. The idol.
Virendra Kumar Das is the only son, 3 daughters, Santibala, Animabala,
No, Birendra is the son of whom? Binod or Bipin?
Bipin Bihari.
Vinod is the son of Bipin Behari Das.
You clarify this confusion.
their claim is that originally the land belongs to the Virendra Kumar Das, but we are stating that it's the land belongs to the late Bipin Bihari Das of village Narikali.
Vinod Bihari Das lordship answering defendant's father. Bipin entrusted Vinod.
Vinod, I
there
don't
to-
know, who is Birenden?
Biren is the son of Bipin. Lord. Vinod is different, Bipin is different.
Vinod and Biren are brothers.
They said Virendra Kumar Das, but we are stating that the original owner of the suit land is Bipin Bihari Das of village Narikali. He bequeathed the property to the Vinod Bihari Das. Vinod, who was entrusted to look after the management of the Kali
And
Temple.
Bidut is the son of Vinod.
Yes, Bidut is the
But
son
who
of
is
Vinod.
Birenden? What is the name of the father of Birendas?
Virendra Kumar Das father's name is Bipin Bihari Das. My vendor is the son of Bipin Bihari and Vinod is a different person. Their father.
But they are saying something else.
Lordship, our written statement in page number 49, just my senior counsel has read out, that is page
Madam,
49.
we can just have a look at this, whatever sale deed certified copy. I think that will clarify, isn't it? You have a copy of the of the sale deeds?
Original I have.
No, original, whatever is, what is the name of the father of Biren Das?
Virendra Kumar Das Pita Mrito Bipin Bihari Das.
Yes. Biren is the brother of Binod, that means,
Maybe Bipin and Vinod are brother.
not Bipin. Binod and Bihari, Binod
No,
and
no.
Biren.
Bipin has only one son.
But you said the
Only
yeah,
one son.
Biren is
My-
the son of Bipin.
Yes, Lordship.
They are saying that Binod is also the son of Bipin.
Vinod is son of Bipin.
He was
Oh,
entrusted.
exactly.
No, she is not saying that, Lordship.
Then who was,
He
who,
is saying Bipin entrusted Vinod. Who is Vinod? She cannot say, but Vinod is her father.
no, what is the name of the father of Binod Bihari Das? Any idea?
This Bipin Bihari, as per my information, it is, the, is the, Bipin Bihari Das is the father of, no, Lordship. Vinod Bihari Das is the father of Bipin Bihari Das. Even our written document page stated, page number 14. Just now, my senior counsel
Binod is
stated.
the father of Bipin. How is it possible? That means Vidyut Bhushan, the present defendant, has to be the brother of Bipin.
No,
Page 49.
page 14.
49.
Just- We say, Dr. I'll just read out, Bipin, Virendra Kumar Das or any of the legal heir of late Bipin Bihari Das have no alienable interest over the suit land. Late Bipin
So
Bihari,
her case is that Bipin Bihari's legal heirs have no alienable interest. Vinod is a different person.
yes.
You did not institute the suit against the idol.
No. Our reply to their counterclaim is also there.
Counterclaim dismissed, we are not going into the validity. That aspect.
But
Whether the implicit judgment decree can be termed as correct in. And therefore, number of 10. 10. 15. Okay. Yes.
For page 50 of our subject,
50.
we have stated this fact by this date. I'll just read out better. The state Virendra Kumar Das never purchased any land, the suit land, with, from
Pritilal.
Pritilal Das, and state Pritilal Das who had no alienable interest in the suit land, so right of inheritance or otherwise. The document of 1350 of 2000 is an
Madam, your
illegal.
defense was very weak. We are not impressed by your defense, but we are also on the aspect that whether they are able to discharge their burden of proof in accordance with law. Your defense which you have taken is that the land in question, they did not have any alienable interest which could have been transferred. But you have done nothing to prove that.
No, because that time I was remain absent. Due to my illness, I was absent during the period of 14 when the judgment was passed. I was
Not at the time of the judgment. What evidence did you adduce to support your pleadings that the Birendra Kumar Das, person Birendra Kumar Das did not have any alienable right, interest, that the property was already bequeathed in the name of the idol, in the name of the devoter, which was looked after by Binod.
no, before I could prove myself, I was remain absent because it is reflected in the page, judgment page.
But ultimately, we'll again come down to the aspect of proof of your document, madam.
In that case, Lordship, I am relying on a judgment.
Plaintiff has to stand on its own foot.
I am relying on a judgment, Lordship, that is 2003 8 SCC page 752. 2003 8 SCC page 752.
2003. Eight SCC 752.
In this case, photocopies were exhibited for para 15, page 762. Edit.
Paragraph
15.
15.
Yes. Paragraph 15 proceeds, the High Court has, by entering into the question of admissibility in evidence of the above state, two very material pieces of documentary evidence, which were admitted in evidence without any objection when they were tendered in evidence and taken into consideration by the two courts below while evaluating evidence and recording findings of facts, excluded the documents from consideration. Was it permissible for the High Court to do so? One document, Exhibit A3, is the photocopy of a certified copy of the decision given by the Charity Commissioner. This document was tendered in evidence and marked as an exhibit without any objection by the defendants. When this was done, the plaintiff has in his statement deposed and made it clear that the certified copy, though available, was placed on the record of another legal proceedings, and therefore in the present proceeding he was tendering the photocopy. There is no challenge to this part of the statement of the plaintiff. If only the tendering of the photocopy would have been objected to by the defendant, the plaintiff would have then and there sought for the leave of the court either for tendering in evidence a certified copy freshly obtained, or else would have summoned the record of the other legal proceedings with the certified copy available on record for the perusal of the court. It is not disputed that the order of the Charity Commissioner is a public document admissible in evidence without formal proof, and certified copy of the document is admissible in evidence for the purpose of proving the existence and contents of the original. An order of the Charity Commissioner is not per se evidence of title, inasmuch as the Charity Commissioner is not under the law competent to adjudicate upon questions of title relating to immovable property, which determination lies within the domain of a civil court. However, still the order has relevance as evidence to show that the property forming the subject matter of the order of the Charity Commissioner was claimed by the temple to be its property, but the temple failed in proving it. In this case, Lordship, secondary evidence was allowed to be adduced without any objection, and even in the absence of a foundation for admitting secondary evidence having been laid by the plaintiff. That was and another judgment, Lordship, 2006 11 SCC page 331.
2006
11 SCC
3.
page 331. 331.
Yes.
para 17, Lordship,
Just a minute, please.
331, and para 17 is page 336.
This is Shyamal Kumar Roy.
Yes.
Paragraph 17.
Objection as regards it
Yes, please.
of a document thus specifically is required to be taken that it was not duly stamped. On such objection, only the question is required to be determined judicially. Reliance has been placed in Ramratan versus Bajrang Lal, which in our
No
opinion,
application, then don't read it in.
Lordship, when there had been no determination as regards sufficiency of the stamp duty paid on an instrument, and in the event the document is taken in evidence with an endorsement that objected allowed subject to objection, this court in Ramratan Lordship, this is so as to enable last part Lordship. 20 paragraph, if no objection had been made by the appellant herein in regard to the admissibility of the said document, he at a later stage cannot be permitted to turn round and contend that the said document is inadmissible in evidence. The appellant having consented to the document being marked as an exhibit has lost his right to reopen the. First of all, Order 41, Rule 27, I am relying on Union of India and Ibrahim Court. That is settled principle of law in this case, that Order 41, Rule 27 petition to be considered at the time of hearing, and that is 2012 8 SCC pay 148.
Para?
Para Lordship 52. It starts Order 41, Rule 27.
Union of India versus
Union of India versus Ibrahim Uddin and another.
Ibrahim Uddin.
Ibrahim Uddin and another.
Okay.
Is still holding the field Lordship. After this, Madras Corporation, one more judgment came Lordship. That is
What are
relying.
it? Please read.
This para 52. It starts from para 36 Lordship. The findings is at page para 52.
Please read.
Thus, from the above, it is crystal clear that an application for taking additional evidence on record at an appellate stage, even if filed during the pendency of the appeal, is to be heard at the time of the final hearing of the appeal at a stage when, after appreciating the evidence on record, the court reaches the conclusion that additional evidence was required to be taken on record in order to pronounce the judgment or for any other substantial cause. In case the application for taking additional evidence on record has been considered and allowed prior to the hearing of the appeal, the order being a product of total and complete non-application of mind as to whether such evidence is required to be taken on record to pronounce the judgment or not, remains inconsequential, inexecutable, and is liable to be ignored. In the instant case, the application under so was filed on and it was allowed on 28/4/1999, though the first appeal was heard and disposed of on. In view of law referred to herein above, the order dated so is just to be ignored. So, as per this decision, Lordship, it discussed from para 36 to Order 41, Rule 27, it starts from para 36. In this section, the Supreme Court held that the Order 41, Rule 27 application to be not to be rejected, it is to be considered at the time of hearing. So my argument in
Just a
regard to
minute. Okay.
one more judgment, Lordship, 2006 5 SCC on registered document. Presumption on registered.
2000?
5 SCC, page 35.
Name?
Prem Singh and others. PRTM Prem Singh and others.
Para?
Versus Para 27.
Okay.
There is a presumption that a registered document is validly executed. A registered document, therefore, prima facie would be valid in law. The onus of proof thus would be on a person who leads evidence to rebut the presumption. In the instant case, respondent number 1 has not been able to rebut the said presumption. Para 27. My humble submission before your lordship.
Okay.
Even if your lordship not considered my application under order 41/27, this suit of the plaintiff has to be decreed as because he has already submitted certified copies. Those were exhibited without any objection.
Then
Admissibility also not any objection was never raised by the defendant, and they are pleading lordship. They are saying that it was bequeathed to them lordship. That was not proved by them. So, and my PW 1 and 2 never cross-examined by the defendant. So, lordship, the pleading of the plaintiffs already proved by the plaintiff by exhibiting the certified copies and through PW 1 and PW 2. So, plaintiff lordship proved his case through oral as well as
But they
documentary.
have produced a certified copy of the document. Lordship, it does not prove the existence, prove the genuineness of the document. Because in the certified copy itself, it's written by somebody, written by somebody else.
some judgment?
Actually, the lordship have not totally prepared with the case because it was my chamber case. So I somehow managed to.
You're not
No,
supposed to prepare.
I was someone managed to get the copy from my senior counsel.
Okay, doesn't matter. You're J. Paul?
Yes.
Okay. Heard.
He already been.
Miss R. Chaudhary, learned counsel for the appellants.
Okay,
Well,
one more,
The respondent is represented by Ms. J. Paul. The hearing is concluded. The judgment is reserved. We'll consider all the aspects.
I did
Lordship, one more thing, just one. Mr. This is a long pending case. They have stated in their order 14 additional affidavit in paragraph that the said appeal came up for hearing before the Honorable High Court, and during the preparation, learned and guest counsel inquired about the original dates from the plaintiff as it is reflected that the plaintiff exhibited certified copies of the said date by which they are claiming their ownership. My humble submission is that lordship is a long pending. Several times it was listed for hearing also. At that time they could not remember. At that time, so they, after long for 15 years, they have come before this court and then stating that is they have existed sale it. So this is not a justified and then
they have not filed any objection. Even
We are
the
supposed to file-
opportunity was
because
granted.
we are supposed to file the objection by during the time this honorable court has put another substantial question of law, that is
Yes.
whether
Okay.
the lower court
IL
justified in-
already notice was issued.
Justification of court that-
Can you give copies of the last two judgments, madam?
Even I have I've been
Union of
given some
India
more
and
time, I can
Prem-
produce some of the
Prem and the other one.
judgments. If I have given some more opportunity, then I judge. I'll try to get the judge.
If you want to give judgment tomorrow by tomorrow, but give at least the citations to the other side.
Yeah, I didn't get that.
Your citations, if you're to depose, if you're to assess this court by giving judgments, give citations to other side also tomorrow.
Yep.
By tomorrow.
Even she also supposed, she didn't give it.
She is making the statement in the court. You are supposed to note. If you give on her back, you are supposed to give them a call, at least the notice. Prem Singh and the other one.
Lordship, just now I have
Okay.
The Union of India and Ibrahim.
Okay.
And one more citation already I have earlier given, Krishnalal Ghosh. That
Yeah.
was our High Court.
Yes, with that we have.
That is TLR.
Okay.
Yep. Okay.
Records are similar, no? I didn't follow.
An application on 620 to transfer the matrimonial case from Tinsukia to Jorhat.
They have not contested.
The present proceeding.
They have not contested.
Yes. Lordship, as per office note dated 3/9/2019, the Lodima could
Yes, well, that we have. There is an interim order also.
Yes,
You're the wife.
I'm the wife.
Please tell us the facts.
Lordship, the marriage was solemnized on 5/10/2005.
Just a minute. Petitioner is the wife.
Yes.
Marriage when?
Marriage was solemnized on 5/10/2005.
5/10.
10,000.
Parties are Hindus.
Yes, but
Okay, marriage is.
marriage was solemnized at Jorhat.
Jorhat.
At the permanent place of the present.
Jorhat.
Yes.
Okay.
Thereafter, they stayed at the matrimonial place at Tinsukia.
Matrimonial house insecure.
Yes. And out of their wedlock, Lordship, male child was born on 28th of November 2000.
20.
Yes.
20th?
Yes.
20th November
2000.
2006. Son.
Yes.
Oh,
And at the time of presenting the present petition, he was a class 5 student.
hmm. Yes.
The case of the thereafter lordship, a proceeding for divorce lordship, that is TSM 19/2017 was initiated by the respondent on the ground of mental cruelty against either.
1917
19/2007
by respondent
by the respondent
for divorce.
for divorce before the Ghana district of Tinsukia.
Yes.
Prior to that, lordship, I filed a maintenance case under section 125, and that is case number 41 of 2016
Hmm. Where?
at Jorhat lordship. Additional district, additional CGM Jorhat lordship.
You had filed prior in point of time.
Yes, sir. And that was disposed by judgment and order dated 6/10/2016 itself.
Disposed when?
6/10/2016. With a
Okay.
direction to the respondent to pay me maintenance at a rate of rupees 6,000 per.
Yes. Yes.
So my humble submission is that presently I have been staying at my paternal place. Presently I am staying at paternal place. Prior to filing the case, sir,
At Jorhat.
at Jorhat. Sir. Presently, my family consists of my old parents, lordship, and my minor son. At the time of filing the transfer petition, lordship, my father was aged about 84 years, and my mother was 75. At present, they are almost 90 years. So, except my father, lordship, there is no male member in my family. And the distance between my paternal house and the court of district judge Tinsukia is about 200 kilometers. So it is my duty to drop my child in his school and to keep back. I used to do those things, lordship. That's because there is no,
Are you working?
no lordship. I'm depending upon the maintenance given by the respondent in the matrix. I have specifically mentioned the ground at paragraph number 5 and 6 of my.
What does he do?
He's a government employee, lord, as
Where?
far as Tinsukia.
Where? No. Where? Which department?
He has not disclosed in the petition itself, lordship.
No. You know what your husband does. Let us see the divorce petition.
At page lordship,
7, 8.
page 8, lordship. Page 8.
Hmm.
at paragraph of my written statement against the divorce petition, paragraph 14, I have stated that the petitioner has a decent income and he is the government employee and draw rupees 35,000.
Now, if it gets transferred here, how will he? He is a government servant.
Yes.
How will he be present in the proceedings?
He can be taken lordship showing his spouse.
No, the same difficulty he'll also face. He is the dominus latus, it is up to him. And he has presented his petition at Tinsukia, which has jurisdiction because the matrimonial home. has a-
Lordship section 19 subsection Roman 2. The jurisdiction is also the
No.
place wherein the respondent is.
You are correct. It is only on regard to jurisdiction if a question would have arisen.
Yes.
Whether Jorhat court has also jurisdiction.
Yes.
Answer is yes.
Yes, yes.
But it is not your case that Tinsukia court does not have jurisdiction.
But
We are adjudicating a petition for transfer.
yes, but
The other side is not contested. That's a different aspect. But the difficulties which you are expressing of going to Tinsukia to defend your case,
Yes.
the same difficulty the plaintiff would also
Also-
have if he is required to come to Jorhat to attend the court.
being a female lordship, that to mother of a minor child and daughter of old ailing parents. So my difficulty is more much than the
No,
respondent.
you are a married woman. The welfare of your parents is of paramount importance, but married women will have to balance. If you are in the matrimonial house, then who would have looked after your
At the
parents?
present circumstances,
No, no.
at the,
Present circumstances is
at the
different.
present circumstances.
No, those circumstances, who would have looked after your parents? Every day you could not have. You might have come once in a while. Can that be a ground?
Also, I used to drop my child.
How far is the school? He reads in the central school at
Central
Jorhat.
school to her.
How far is the house, school from your present stay?
As per the address shown in the petition lordship, they are not resident of proper Jorhat town. They used to live village again. There may be some distance.
No. Tell us how much, what is the distance? This transfer petition was presented in 17.
Yes, Lord. But they are not listed.
Okay. Please have your seat. The instant petition has been presented under section 24 of the Code of Civil Procedure, praying for transfer of title suit within bracket matrimonial number 19 of 2017 from the Court of the Learned District Judge Tinsukia to the appropriate court at Jorhat. Jorhat, you have family court.
Sir.
Jorhat, do you have a family court?
Yes, district judge is the
No, do you have a family court or not?
district judge, Lord.
District judge, okay. Don't say district judge is the family court. Family court is a different context altogether under the Family Courts Act.
Yes,
District judge acts as the authority under the, not under the Family Courts Act. But there is no family court in this.
There is no
Okay. Before the appropriate, okay, Jorhat within bracket, district judge. Full stop. The grounds cited are hardships. No, don't say, don't write this. The facts projected in the petition are that the marriage of the petitioner was solemnized with the respondent on 5/10/2005 at Jorhat. Full stop. However, the respondent being employed at Dumduma, comma, the matrimonial house was at Tinsukia. Full stop. On 2011/2006, a son was born out of the wedlock. And at the time of presentation of this application in 2017, comma, the son was a student of class 5. Full stop. Para. The respondent had instituted the aforesaid title suit for divorce before the Learned District Judge Tinsukia. Full stop. It is contended that prior to such institution of the divorce proceeding, comma, the petitioner had filed a petition for maintenance before the additional CJM, Jorhat, being case number 41 of 2016, in which orders towards payment of maintenance at the rate of ₹6,000 was passed on 6/10/2016. Full stop. It is the categorical case of the petitioner that she is residing at Jorhat at her parental home, having aged parents and the minor son who is attending school at Jorhat. Full stop. There are no male members except her aged father, and accordingly, the present application has been presented. Full stop. I have heard Sri R. Sharma, Learned Counsel for the petitioner. Full stop. Though notice was issued in this case way back on 23/10/2017, comma, the respondent has not appeared. Full stop. In fact, in a subsequent order dated 6/3/2020, this court had accepted the note dated 28/2/2020 of the learned Lozima Court regarding completion of service upon the sole respondent. Full stop. This court has also noticed that in the initial order dated 23/10/2017, by which notice was issued, further proceedings of title suit number 19 of 2017 was kept under suspension, and the said interim order was continued, which is presently in operation. Full stop. Para. The learned counsel for the petitioner has submitted that the minor son is attending his school, within bracket central school at Jorhat, and it is only the petitioner who is to take care of him in all the activities. Full stop. It is further submitted that it is practically, it is absolutely difficult on the part of the petitioner to attend the proceedings at Tinsukia, Tinsukia, as the distance from Jorhat to Tinsukia is about 200 kilometers. Full stop. It is submitted that the respondent husband, on the other hand, is a government servant and can afford to conduct the case at Jorhat if the prayer made in the petition is allowed. Full stop. The aspect of lack of any other male members in the parental house of the petitioner, except her aged father, has also been highlighted. Full stop. Para. As observed above, the respondent has chosen not to contest this case in spite of receipt of notice. And from 2017, the proceeding is at a standstill because of the interim order, which is perhaps not in the interest of justice. Full stop. However, in spite of the fact that the present petition has not been contested, this court is required to look into the reasons assigned for justifying the present prayer. Full stop. Para. The petition is presented by the wife who has a minor son and are presently staying at her parental home at Jorhat. Full stop. Without even going to the inter se marriage of the respective parties, which would be decided by the appropriate court on the aspect as to whether a decree of divorce is to be granted or not, this court is of the opinion that interest of justice would be met, would be served if the proceedings in title suit number 19 of 2017 are transferred from the court of the district judge Tinsukia to the court of the district judge Jorhat. Full stop. This court has also taken into consideration that, as observed above, the stay of the proceedings from the last more than more than 7 years is benefiting none. Full stop. Para. In view of the aforesaid, in view of the above discussions, the present petition is allowed and the proceedings in TS within bracket N Pura Likhiba 19 of 2017 pending in the court of the learned district judge Tinsukia be transferred to the court of the learned district judge, Jorhat. Full stop. On receipt of the records, the learned district judge Jorhat is to issue notice to the respective parties, more particularly the respondent herein, who is the first party, as the said respondent is not present at the time of adjudication and passing adjudication of this case and passing of the present order. Send back the records. Okay. Much. Title suit pura namto likhi diba. Title suit number N ase nahi given. Okay, next.
Item 5.
Yes.
But this is second appeal against the order passed by the first appellate court, whereby the application for condonation of delay in filing the first appeal was checked, and thereby has not gone into the merit of case. And accordingly, we have come before you.
That is the only point involved.
That is the, my lord, at the time of admission of appeal, that was the point. And
That is the only point. If
Yes.
if the delay condemnation was not
yes,
was rejected, that means the court did not enter into the merits.
not
How much was the delay?
only 25.
Yes,
30 days.
Mr. Biswas,
Yes, I have no objection if the delay is component.
we send it back. And
Yes,
as you know, decision on limitation is also a decision on merits.
yes.
So it's only an appeal which will lie.
Yes.
And not a revision. This is explained.
Yes.
So we'll allow this.
Yes.
Why was it rejected?
Not sufficiently explained as per
But
the first appellate court.
The earlier engaged counsel expired. Basically, my lord, earlier engaged counsel expired, and this was also, my lord, evidence was also, my lord, given by the counsel. But court at its discretionary.
What is the suit for? You are the plaintiff,
No, I am for dependent.
defendant.
I am the plaintiff. I filed a suit for declaration that defendant cannot sell the part of the dwelling house to a third stranger. As per section 44 and of the Transfer Property Act and section 4 of the party.
Okay.
So my suit was decreed.
Just a
against
minute,
the
just a minute. Appellant is the defendant.
defendant.
Suit for
Declaration that the defendant has no right to transfer it.
transfer some land.
Yes, parental dwelling house.
Dwelling house only.
And land to strangers.
Hmm?
And land.
Your brothers,
Yes.
why didn't you settle?
Already, my
You
lord.
sell it to him.
No, my lord.
I approached him.
You
But
sell
he
it to
denied.
him. If you want to some
the-
money, sell it to him.
The
And
premature.
you are, I think you are practicing medical practitioner.
Yes.
Why do you want?
No, no, thing is that, my lord, already I am residing a separate personal plan. Mine is already demarcated, man. And there was an
No,
imperfect.
if it is not disputed that the land and building involved is a parental property, and your share, you want to alienate to him, matter ends there.
So I am residing a separate that number, man. And he is residing in the parental dwelling house. We are not disputing that. But they have projected a case whereby my land and house is, my lord.
Part of the parental house, which you are saying that it's not a part of.
No,
parent.
it is clear case. Finding is perverse. Issue number 4 is.
Mr. Biswas,
That is the finding, my lord. That-
why are you after his land?
But as far as our contention is, my lord, it's a part of the parental dwelling house. So we request.
Was it decided that is issue?
Yes, my lord, it is decided.
Issue number 4, man.
It's a part of the parental house. That is
Yes,
the okay.
Court without going into the cross-examination and my defense that order was passed.
Okay. Please have your seat. এটা আর হবে না ফটাফট But substantial questions of law.
But this is only the substantive question of whether the delay part is.
Where?
Already framed, man.
What are the substantial questions of law?
Not, I think it's in the. I have. Can I?
No. Where is the substantial question? Have you seen?
Yes,
Have
my
a
lord.
look. I don't know.
For about delay, my lord, there is no question being said. Only about section 4.
Appellate court did not even have the opportunity to go into these aspects.
Yes.
And the second appellate court,
I have seen, my lord.
when did you present it? Did you present a substantial question of law at the time of presentation of the appeal?
Yes, my lord.
When did you
was
present this paper, this document, Mr. Barua? Was it presented at that time?
No, these are additional.
These are the only.
We are earlier granted leave to file additional substantial. Or any other substantial question is written, my lord, may be taken up at the.
No, but those questions can we decide, which has not even been touched by the first appellate court.
But,
আমার ডিসিশন আসলে নহয় that second appellate court can also modify the assay decision. Mr. Barua, there are decisions where even the second appellate court can modify
Yes,
the
yes,
substantial questions of law framed if the facts so
Yes.
require.
yes.
Do you have decisions?
That I don't have that now.
এতিয়াতো সময় নহব আধা আধা হৈ থাকিব 3 বছৰ দিম দিয়া judgment. We'll pass the judgment at 2 o'clock. Now it will be half done. Okay.
Basically, your lordship will demand the matter.
We'll allow this. Now we'll dictate in the open court. Now, no point in 5 minutes will not be
Fine.
over. Madam Bora, which is your matter? Some important matter or what? Huh? Very important. Very important.
But
More,
they have the tensions of it, they have to pay us a single amount.
more important than 4th of June. Is it more important than 4th of June?
I was there, but she doesn't know.
You were there, we are not there. Okay, we'll come, let us see. Yeah, after the dictating of the judgment, if you have time, we'll do it. Lekha. The instant appeal has been preferred under section 100 of the Code of Civil Procedure, challenging a judgment and decree dated 26/8/2016 passed by the learned civil judge Sibsagar in title appeal number 26 of 2016. Whereby the application for condonation of delay in preferring the said appeal has been dismissed, full stop. The appeal was preferred against the initial judgment and decree dated 16/11/2015 passed by the learned Munsif number 1 Sibsagar in title suit number 77 of 2010. Full stop. The appellant was the defendant in the said suit. Full stop. Para. The title suit 77 of 2010 was instituted by the present respondent as plaintiff for a declaration that the defendant has no right to transfer the parental dwelling house and land to strangers. Full stop. It was the stand of the appellant defendant that the property which he was seeking to transfer was not the parental property. Full stop. Be that as it may, comma, the suit was decreed in favor of the plaintiff by the judgment and decree dated 16/11/2015. Full stop. Para. The appellant herein had preferred an appeal before the learned civil judge Sibsagar in title appeal number 26 of 2016. Full stop. The said appeal, however, being barred by limitation, comma, an application was filed under section 5 of the Limitation Act 1963 for condonation of delay of
31 days.
31 days. Full stop. The learned civil judge Sibsagar, however, vied the impugned order dated 26/8/2016 had has rejected the application for condonation of delay, and consequently, the title appeal was also dismissed. Full stop. It is the legality and validity of the said order which is the subject matter of challenge in this appeal. Full stop. Para. I have heard Sri B. Barua, learned counsel for the appellant, whereas the sole respondent is represented by Sri S. Biswas, learned counsel. Full stop. The records of the trial court have also been requisitioned and have been perused. Full stop. Para. Sri Barua, the learned counsel for the appellant, has submitted that the learned first appellate court had taken a hyper-technical approach in considering the application for condonation of delay. Full stop. Though sufficient reasons were assigned justifying such delay, comma, the same was not taken in the proper perspective, and though the delay was of only 31 days, comma, the same was not condoned, leading to consequent dismissal of the appeal. Full stop. It is submitted that the learned first appellate court had ignored the settled principles of law governing the adjudication process of a delay condonation petition, which requires a pragmatic and justice-oriented approach. Full stop. He further submits that because of the impugned order, comma, the appellant has been deprived of his substantive right to have a fair adjudication at the appellate stage. Full stop. Para. Sri Biswas, S. Biswas, learned counsel for the respondent, has, however, submitted that the impugned order dated 26/8/2016 has cited reasons for disallowing the application for condonation of delay, and the reasons being cogent, comma, no interference may be made. Full stop. The learned counsel, however, fairly concedes that the delay is not an inordinate one. Full stop. Para. This court has noticed. No, at the outset, comma, this court would like to clarify that dismissal of an appeal, which is a consequence of rejection of an accompanying application filed for condonation of delay, is held to be a decision rendered on the merits of the appeal, as has been clarified by the Honorable Supreme Court in the case of, what was the Radhesham, or what was the name?
I have one Isha Bhattacharya.
No. After that, Radhesham, the first case. What was the case? In Radhesham, no, Sam Sundar.
Sam.
Sam Sundar. Do you have the citation?
I have the Isha Bhattacharya.
Isa Bhattacharya also has some just see.
I have
Sam Sundar reported in so and so. Huh? Two 2004 there was a judgment. On this. This is not on that point. You have not understood what we are trying to say. This is only on the point of limitation.
Yes, sir.
No, that it will be a second appeal, not a revision.
Yes.
That was explained by Sham Sundar. By help as reported in so and
This
so.
correct, 2005. what
Yes,
is
five or four. What is the
Page
name?
Yeah.
Name of the other one versus Pannalal, yes.
Yes.
Sham Sundar, huh? It would murder him. In that view of the matter, comma, there is no issue at all in preferring the present appeal, which is the prescribed approach as per the settled position of law. Para. This court has, however, noticed that while admitting the appeal, Wide order dated 5/5/2017, two substantial questions of law were framed, which is reproduced as hereunder. Full stop. Consequently, comma. Oh no. Para. An observation was, however, made that any other substantial questions of law may be formulated at the time of hearing. Full stop. Para. On perusal of the materials on record, comma, it clearly transpires that the only issue which has been raised is on the legality of the order dated 26.
Page 20. 26/8/2000.
26/8/2016, by which the delay condemnation petition of the appellant was rejected by the first appellate court. Full stop. Para. In the case of so and so versus so and so, comma, the Honorable Supreme Court has laid down that it would be open for the High Court to modify the questions of law, substantial questions of law, which were initially framed, depending on the facts and circumstances. Full stop. In the considered opinion of this court, comma, it is the question with regard to the approach of the learned first appellate court in dealing with the application filed under Section 5 of the Limitation Act, which would be the issue requiring a determination by this court. Full stop. Accordingly, comma, on consent of the learned counsel for the parties, the substantial question of law is reframed in the following manner.
But the refer this is like
What is this?
formulating subject question of law, taking records to provide to Rule 5 of section 8.
In the aforesaid connection, following question, huh? It would number 2 to debate. The aforesaid aspect has also been done in tune of the principles laid down by the Honorable Supreme Court in the case of Vijay Arun Bhagat versus so-and-so, reported in so-and-so, wherein the Honorable Supreme Court had taken into consideration the proviso to section 100 within bracket 5 of the CPC. Full stop. Para. To examine the aforesaid aspect, comma, it is not necessary to have a meticulous examination of the record of the trial court records, as the scope of examination is only with regard to the views of the first appellate court expressed in the order dated 26/8/2016. Full stop. Para. It is not in dispute that the delay in preferring the first appeal was only 31 days. Full stop. It is also not in dispute that the appeal preferred before the first appellate court was duly accompanied by an application under Section 5 of the Limitation Act 1963. Full stop. Though it is a settled principle that the said process cannot be turned into a mere mechanical process, comma, what is required to be taken into consideration is whether the approach of the party in whether the conduct of the concerned party in approaching the court was found to be negligent, and whether there was any deliberate laches on its part. Full stop. Para. In the instant case, apart from the issue that the delay in question was only of 31 days, comma, this court has noticed that reasons were assigned for explaining the said delay. Full stop. The learned first appellate court, however, appears to have taken a hyper-technical approach in seeking every day's explanation. Full stop. The Honorable Supreme Court in the landmark case of Katiji was the case, yes, landmark case of collector within bracket LA versus Katiji, Katiji, reported in 1987, 2 SSC 107 has laid down that there is no strict requirement of explaining each day's delay, full stop. In the case of Isha Bhattacharjee, report versus so reported in so, the Honorable Supreme Court has laid down certain principles to be followed while deciding a delay condonation application, which are extracted here in below, paragraph 21. Para. Examining the impugned judgment in the context of the settled principles of law, it appears that the learned First Appellate Court had swayed away from the requirement of having a pragmatic and justice-oriented approach. Full stop. The impugned order, judgment and order dated so and so accordingly, passed by the learned so and so is accordingly held to be unsustainable in law. Full stop. The appeal is accordingly allowed by remanding the matter to the learned First Appellate Court to consider the entire application afresh. We'll do one thing. We'll direct for merits, remanded the matter to be decided on merits by considering that the delay of 31 days has been explained and accordingly condoned. Full stop. The records be sent back expeditiously.
Date of appearance.
Since the rival parties are represented in this court, let the date of appearance before the learned First Appellate Court be fixed on. Yes, tell us.
Any day last week of June.
Record has to go.
Record will go, no problem. Let it be immediately on the reopening of the vacation.
Yes.
Okay. On 16th of July.
16th of
Whereafter the learned court will proceed in accordance with law.
the registry may be directed to court with 10.
We have already sent.
Obliged.
I think so, yeah.
My senior is in election another court.
And her senior is celebrating. Madam, are you in a mood to do cases or what's the TV?
Saving his temper.
No, today he'll be excused. Yes, you need time. What is it? Which item?
Item 7.
18 matter. Yes, why are you seeking time? When will you be able to do 18 matter? We are
No,
not
Lordship,
adjourning.
yes.
Yes, you are
Yeah.
there.
Yes.
What is the matter about?
Lordship. This is in the title suit, Lordship. We are the defendant and respondent herein we are the plaintiff.
This suit was for what?
For right title interest and the confirmation of possession.
Okay. Yes, we'll go ahead then, madam. The record is in. You are the
We are
Plaintiff.
defendant,
defendant. How many of you?
3 lordship.
Defendant. Suit for declaration.
It for right title interest and confirmation of position.
Okay.
Title suit was in the title suit, lordship, defendant have filed a counter claim also, lordship,
You had filed a counterclaim.
counter claim.
Okay.
And both the title suit and the counter claim was dismissed on contest.
Date?
So 20 January 2011,
20,
21st January,
21st,
Yes,
21, 21/1,
yes, lordship,
2000,
11 lordship.
which court?
London Munship number 2, Dhubri, lordship.
Okay. Both dismissed.
Both dismissed.
Okay.
Lordship, thereafter the plaintiffs filed the title appeal, lordship.
Okay. Title appeal number?
Title appeal number, lordship. '23 of 2015.
23 or 15?
23 of 11, lordship.
11. Okay.
And
Against dismissal of the suit.
against dismissal of the suit.
Okay. You did not prefer any appeal.
No, Lord. And thereafter, in the appellate court, lordship, reversed the judgment.
Which court?
Civil just to appeal.
Okay. Appeal allowed.
Appeal allowed.
Yes, thereafter what has happened?
Thereafter, we have filed this RSA, lordship. And substantial questions, three substantial question was brought.
Yes.
Lordship, in the plaintiffs have claimed their right title or interest in the suit land through a pattanama executed by the original pattatar. Original pattatar was the ancestor father of the pro forma defendant. According to them, lordship, that father of the pro forma defendant settled a portion of his land, which is the suit land, lordship, in favor of the plaintiff number 1
Father
of the pro forma defendant, lordship.
the pro forma defendant settled portion of the suit land.
No, the suit land, lordship,
Oh, settled.
settled to the plaintiff number 1, lordship,
By what?
to a pattanama, lordship.
What is the pattanama?
Pattanama, Patian, lordship. And thereafter, he possessed the suit land, lordship,
Khatian was in the name of the plaintiff number 1.
plaintiff number 1.
The plaintiff was you were a riot or what? You
Riot,
were a riot
Riot.
of the pro forma defendant.
No,
Yes,
father,
lordship,
Father of the pro forma
father of the
defendant.
pro forma defendant gave
And
copy of-
you took into the account 1971 Act.
Yes,
under section 23.
Yes.
Khatian was
I think Khatian
issued.
was issued in our,
Okay.
and later on their objection that Khatian was lordship cancelled. So we have filed suit for right title, and that cancellation is legal with that prayer.
That order passed under the Tenancy Act, Occupancy Tenancy Act of 71, that was the subject matter, that was cancelled.
Cancelled.
And that cancellation was the subject matter of the suit.
Yes.
And his counterclaim?
His counterclaim is that lordship, no patronama was given in favor of the plaintiff, so we are not entitled for this right. We are only partnership position. There, so eviction.
No,
of
why
the-
counterclaim? Counterclaim is with a particular prayer
As we are in the position of the land.
for evicting.
No
you.
right title was lordship preferred by the counterclaimants, only eviction of the plaintiff.
Eviction.
Yes.
Okay. Khatian issued. Khatian was issued. When was the Khatian issued, madam? Okay, when was it cancelled? The subject matter of your challenge in the suit.
In its case number 14 of the 2004, para 5 we have mentioned.
Which is the order?
They have the Hamidul Islam, para 5, we have mentioned that one Hamidul Islam, defendant number 2, filed a petition on 8/12/2003 before the defendant number 6 for all the defendants praying for correction of records of the present suit in their names, which was numbered under case number 14 of the court, in which some false, fabricated and motivated reports were collected, and the defendant numbers 1 to 4 through misrepresentation of facts collusively in connivance with the defendant number 6 and 7 procured an order on 3/5/2005 from the defendant number 6 for cancellation of the Rayati Khatian of the plaintiff
3/5?
2005 and got corrected in the names of the defendant number 1 to 4.
Okay, and this cancellation order was the subject matter of challenge in your suit.
Yes, my prayer was for a degree of declaration that the plaintiffs have right title interest with confirmation of possession of the lands described in Schedule B as per Rayati Khatian. For a degree of declaration that the defendant number 6 has no legal authority to cancel the Rayati Khatian already issued in the names of the plaintiff, and the defendant number 7 has no legal right to correct the land records of the land in the names of the defendant number 1 to 4 on the basis of illegal order of defendant number 6. For a degree of
Okay.
permanent injunction restraining defendant number 1 to 4 and their men present from interfering and dispossessing the plaintiffs from the suit.
Okay.
Their counterclaim prayer lordship. Page 11, a decree declaring that plaintiffs were mere permissive possessor over the land of Schedule B and are devoid of any
But
title.
tell us one thing, madam. You are in position.
But-
Your suit has been dismissed. But their
Counterclaim also-
counterclaim seeking eviction is also dismissed. Your position has not been disturbed.
So I have immediately filed title appeal. They have not filed any
No,
title
why did you file the title appeal?
because my suit was
No,
That
your position,
cancellation
your position has not been disturbed.
possession not disturbed, but lordship that Rayati Khatian was cancelled. So I have to correct the Khatian in my. as-
But there was no specific challenge to the cancellation process. That is what we are trying to extract from you. You have just read the relief which you had prayed before the
No.
trial court.
For a degree of declaration that the defendant number 6 has no legal authority to cancel. So if that comes first, then the cancellation order will go. Then our
Who is defendant number 6?
defendant number 6
Settlement officer.
settlement of
He does not have the authority.
My case that he can cancel the Raiti Khatyan, it was under 1971 Act. So Lordship, that matter number 6 cannot.
Who can cancel?
Lordship,
Which authority can cancel?
that Lordship, it's a Raiti Khatyan, and I have already Lordship occupied the landowner's side.
No, that is a different aspect.
Lord. So my Khatyan
No,
cannot
see,
be
on the merits of the decision, it's a different aspect.
Lord.
Whether the cancellation was legal or not. But if you said he does not have the authority to cancel, that means you are challenging the jurisdiction.
Yes.
Then if he doesn't have the jurisdiction,
1971, as per 1971 Act, I have already got the landholder's side, non-evictable tenant. So
now if there is any mistake or such orders have been procured by some fraud in a given case,
Fraud.
then will it mean that nobody will have the right to cancel it?
those were the prayers when as my suit was. So
No, you
immediately-
have to make one point clear.
Sorry.
Your challenge to the order of cancellation is based on the jurisdictional aspect or legality aspect. If it goes to the jurisdictional aspect, it will go to the root.
Sorry.
He is not even the authority.
Sorry.
Who could have even gone into the aspect of correctness or incorrectness?
He
But
has
if he has
no-
the authority,
He has no legal authority. It was the plain.
then which authority has which authority can exercise such powers?
That settlement officer not have the authority. But Lordship, if I evictable tenant, Lordship, then my British landlord Lordship can evict this person, Lordship, as these are tenants under.
See, no. See, there is an act of 1971
Yes.
which recognizes certain rights for persons without land and who are riots.
Right.
You make an application under section 23.
Right.
Considered, if you fulfill all the factors, you have been given the right to over the non-evictable right. Now, if such an order is procured in a manner which is not recognized by law,
Even maybe
by a
without
wrong
issuing any
appreciation
notice.
or because of any mistake,
Right.
will it mean that such orders cannot be rectified? It can be. So 1971.
Here saying that Lordship, that we have continuing subsisting possession with the right and title acquired by implication of law of Tenancy Act 1971. Rayati Khatyan was issued in the name of the plaintiffs in respect of the lands they have been possessing as described in Schedule B. Lordship may see section 6. Lordship. Instance of occupancy rights and occupancy
No.
tenant shall have permanent, heritable and transferable right of use and occupancy in the land of
1971 এখন বেলেগ আছে।
Assam temporarily secretary of state. Assam landed. Page 156.
Yes.
Three power given to deputy governor.
Yes.
And on number 6. 13.
Nine.
If there are areas of rent, then also he cannot be evicted on the 35th
Except for others.
area can be his holding shall be liable to sale.
No, an order which has been passed in accordance with section 23.
Not-
Against that, an appeal will lie, I think.
And appeal will tie to the court.
Revenue board, I think.
Yes, but here in this case, they praying for right title interest. So that right title interest that cannot go to REP. Along with right title interest, they are praying for.
No, we are on a slightly different ground. See, your contention is that you being the riots, your rights were recognized in taking recourse to 23. Now that recognition was cancelled, not by the revenue board in an appeal, but by the settlement officer. So you may be correct in contending the jurisdictional aspect also.
When they receive, they put a question mark to the position and right title of the plaintiff, that there's a need to seek for a right title interest of the prayer of the plaintiff for civil court. So
So
instead-
then you file the suit, then thereafter you file the appeal after this dismissal of the suit.
Yes, but they have not preferred, the defendant have not preferred any title appeal against the
Of the counterclaim.
counterclaim.
Oh.
And it is reflected in the title suit also that even after filing of the title appeal,
Hmm.
they have not preferred any cross appeal. That is reflected in the title appeal judgment also.
No, that is not disputed.
But page 38, the defendant
Title appeal. No.
did not
appeal.
file cross appeal or cross objection.
Okay. Then what happened? The appellate court.
Appellate court held that Lordship Patronama that is given by Ganesh Sarkar, who is the original owner, and defendants are the legal heirs of Ganesh Sarkar. That is a 30 years old document as per section 9. It was believed to be a true copy. That is not a, this is an original copy submitted by the plaintiff from its proper custody. So that was believed by the first appellate court, and accordingly right title interest of the plaintiff that
The presumption of under section 90 of the Evidence Act was invoked.
yes. Page 40, it starts from page 40. I have perused the Indian judge and case record.
Okay. But the Pattanama was exhibited as what? Exhibited as
Exhibit one.
Exhibit 1.
Yes.
But Exhibit 2 is only a receipt, rent receipt, which
Yes.
did not have any signature.
It was stated that hand receipt was written by Abdul Ghani Sarkar, that is the father of the book, but no signature was.
There was no signature. So
That
how
was-
was it constituted to be a rent receipt?
One PW code was there. PW code or PW.
Now, document which does not bear a signature, how do you constitute that to be a receipt? And let us see Exhibit 1. Let's see. Exhibit documents. Exhibits are difficult to be appreciated, all torn. Let us have a look at the first appellate judgment.
Page
Page
33.
33.
Yes.
Yes, please. Please read. Sheet of audio পড়িনি, এসব লাগিয়ে দিলে হলো।
Page number 35, Lordship, paragraph number. The plaintiff appellant had instituted a suit against the defendant alleging that therein that a plot of land measuring 7 acres, 1 quarter, covered by Miyadi Patal number 24, Cozy number 24, Fact number 26, situated it was originally owned by one Farid Sarkar, and after his death, the aforesaid land was inherited by his son, Abdul Ghani Sarkar, that is the predecessor of the former defendant, the former Rashid. The plaintiff had pleaded that Abdul Ghani Sarkar during his lifetime settled the plot of land measuring 10 quarters according to Koreabari measurement in favor of plaintiff number 1, the Abdul Sahid, as tenant and delivered the possession of the same in the February year 1360. According to the plaintiff, Abdul Ghani Sarkar died sometime during the year 1920. The plaintiff had pleaded that the plaintiff number 1 became the permanent tenant under the landlord Abdul Ghani Sarkar under the Assam Temporary Fiscal Areas Financial and obtained riotic title in its name. According to the plaintiff number 1 transferred a plot of land measuring 12 places to plaintiff number 2, Sri Noor Abedin, and transferred another plot of land measuring 16 places to the predecessor of plaintiff number 2, Wajibur Rahman, and thus a plot of land measuring about 3 quarters 4 places remained under the possession of plaintiff number 2, and that all the plaintiffs constructed their restricted in the respective plots of land and started to reside there. The plaintiff have described this plot of land which remained in the possession of the plain and carrying after short years the plaintiff have alleged that defendant number 2, the Hamudi Discount, had a petition on 8/12/2002 before the settlement office. Defendant number 6 and got the riotic title cancelled which stood in the name of the plaintiffs and got the names of defendant number 1 to 4. That is respondent number 1 to 4 reported therein in miscase number 14 of 2004. And on the basis of the supposed illegal mutation, they are claiming the land belonging to the plaintiffs and are trying to evict the plaintiff. Hence, this suit claim for the declaration of right capital interest of the plaintiffs for the suit land and ensure for correction of the revenue records with the names of the plaintiffs by cancelling the mutation in favor of number 2 4. The defendant number 1 to 4, respondent number 1 to 4, filed their joint defense statement along with a counterclaim, stating therein that the suit is not maintainable, the above mentioned competitive of ever allotted or settled with the suit land by Abdul Ghani Sarkar as alleged by the plaintiffs, and that the plaintiffs are not the riots, as such they do not have any permanent equitable right. Defendant has pleaded that Farid Sarkar, the original owner of land measuring 13 acres 14+7 to another AE 2 number 330, of which the eastern part got submerged in river Alur, and the western part was sandy, which was recorded in doc number 196 under item number 250. According to the defendant, the plaintiff illegally occupied the southwest part of the above land and illegally came to be the tenants and got their names recorded as riots illegal. As such, the defendant applied cancellation of the sale and got the names of the plaintiffs cancelled by order passed in misstatement of sales. The defendant had further contended that the aforesaid land was originally possessed by 2 tenants, namely Nazimuddin and Kasimuddin, but they defaulted in payment of the rent, and as such, the same was sold in auctions in case number 12. The defendant further contended that they inherited land measuring 7 acres under that number 12 number of Richard. But the plaintiff took possession of 4 quota 10 acres of land, and when the land emerged from river bed, defendant further alleged that the plaintiff took the quarter settled bid on sometime during the year 1988 at the time of patch by constructing temporary ships but later on in the year 1989, illegally got their names recorded prior in the settlement of the The defendants has contended that they came to know about the mutation of the name to the plaintiff in the year 1994. Hence, they applied for cancellation of the same and got it cancelled in mid-September. The defendant had contended plaintiffs are the permissive occupiers in respect of the suit at such paid for eviction of the plaintiff. The plaintiff filed a written statement against the counterclaim and stated therein that the counterclaim is not maintained. Plaintiff's father contended that number 1 to 4 are not the linear descendants of Farid, who was a citizen.
Mr. Chaudhary, in the first part, there is slight confusion. At page 35, you said that initially one Abdul Ghani Sarkar during his lifetime settled a plot of land measuring 10 katha, correct? To the plaintiff number 1. So total area is 10 katha.
Yes.
Then the observation of this court, plaintiff number 1 had transferred 12 lechas to plaintiff number 2 and 16 lechas to plaintiff number 3.
Yes.
That means total 28 lechas.
Yes.
28L, which is equivalent to how much? 20 lechas make 1 katha.
1 kata,
1 katha 8 lecha. 1K 8L. And thereafter, you see the observation thereafter. And the remaining portion is only 3 katha 4 lechas. Why?
yes, sir, this is not as per our measurement. This is according to Koreabari measurement. It is somewhat different. Exact length is
There is no dispute to this proposition. As per the measurements which have been
It is-
done by that, for it is okay.
okay. Look,
That means total out of 10 katha, if you transfer 28 lechas, you'll
3 kata 4 less.
maybe
This is not disputed because as this measurement is according to Koreabari measurement, it is somewhat different. Look. It is stated in the plaint itself.
Koraibari.
Koreabari Lordship at page number 6, Lordship.
Okay, then okay, then let us proceed.
Paragraph number 7.
Hmm.
The plaintiff filed a written statement against the counterclaim and stated therein that the counterclaim is not maintainable. The plaintiff for the counterclaim 1 to 4 are not the linear descendants of Farid, was a citizen of East Pakistan. As such, they do not have any right to inherit the plaintiff further contended that the suit then was settled by Abdul Ghani Sarkar and they acquired the rights of permanent tenant and were residing thereon, constructing their residential. At such fate for dismissal of the counterclaim, the plaintiff further denied that they were permissive occupiers in the suit. On hearing the learned trial could from the following issue. These are the issues.
Hmm.
So paragraph number 9. During the trial, both the parties laid evidence.
Yes.
Will come to discussion.
But just a minute. Choose. Yes, please.
Yes, paragraph number 9 once for a second. During trial, both the parties laid evidence in support of the case. For trial on both the sides, the Gardner trial court with a impugn judgment case and so dismissed the suit as well as the court. The following issues are from discussion now. Okay, paragraph number 10.
Yes.
I have carefully reduced the evidence and materials available from page what I have purchased and 11. Let me discuss the grounds taken in the memorandum of full along with the relevant institution. Point for determination number 1, whether the learned trial court has rightly decided the issue number 1, 6, and 7, wherein it was held that the plaintiff have failed to prove their right title and interest for the suit plan, and also held that the defendants are not entitled to recover first position of. The learned counsel for the plaintiff's appellant, C. H.M. Dasan, considered the trial court had erred in holding that the plaintiffs have failed to prove that they are riots in respect of the suit plan because the plaintiffs have produced the pattanama executed by the owner, Abdul Kuni Sarkar, in favor of the plaintiff number 1, and had also produced the riot items listed in the names, which shows that the plaintiffs are the riots having permanent and physical right over the. The learned counsel for the principal respondent number 1 to 4 Steve K. Jain and the trial court had tightly held that the plaintiffs have failed to prove their legitimate. I have perused the impugned judgment and case. The perusal of the impugned judgment feels that the learned trial court had ignored the pattanam exhibit 1, by which the plaintiff number 1 allegedly came in possession of the suit plan as a riot under Abdul Ghani Sarkar way back in the year 1956. The learned trial court, having an impugned judgment, observed that the plaintiff witness could not state as to when the aforesaid exhibit 1 was executed, and as such, the learned trial court did not consider that. The learned trial court had also observed in the impugned judgment that the plaintiffs have not averred that they had paid rent to the land. As such, the plea of leniency of the plaintiffs was not believed by the learned trial. Now let me discuss the entire material to court and try to erect an independent findings as regards the court. The plaintiff number 1, the Abdul Sahib, had proposed that the Abdul Ghani Sarkar, who was the owner of the suit, had settled the suit then in court of the by execution of pattanama of that exhibit. I have perused the exhibit, and it appears that the exhibitants Abdul Ghani Sarkar had settled the suit land in favor of plaintiff number. The Abdul Sahib, as a tenant upon payment of rent, and had even fixed the yearly rent of the suit. The PW wants the Abdul Sahib has identified the aforesaid pattanama and had stated in his cross-examination that the pattanama was written by one Somesh Sarkar and was executed by Abdul Ghani. It is an admitted fact that Abdul Ghani Sarkar is presently there. The perusal of exhibit 1 reveals that the aforesaid pattanama was executed on 27/13/62. The Bengali year of 1962 corresponds to the English year of 1956. As such, it is seen that the exhibit 1 is a document which is more than 30 years, hence the legal presumption on the 30 of exhibit 1870 can very well be drawn, and it can be presumed that the aforesaid exhibit 1 was properly and duly executed by the Abdul Ghani Sarkar. The fact that the exhibit 1 is a document is more than 30 years old and is produced by the plaintiff number, who is the person in whose favor the suit then was still at the exhibit 1, and it shows that the production of the above document is done from proper custody. In addition to the above, it is admitted fact that Abdul Ghani Sarkar, the executant of the above document, is dead. At first, it is held that the plaintiff have properly proved the execution of the exhibit 1. The PW wants the Abdul Sahib had further produced the rent payment receipt marked as exhibit 2 and exhibit 2 to show that the state paid that he had paid the rent of the suit land to Abdul Ghani. Perusal of exhibit 2 reveals that the same pertains to Bengali year 1362, that is English year 2000. The PW1 was cross-examined in respect of the aforesaid document, and in his cross-examination, it specifically stated that exhibit 2 rent payment receipt was sent by Abdul Ghani. There is nothing on record to doubt or believe the above statement of it. In addition to the above, the exhibit 2 is also a document which is more than 30 years and is produced from proper custody of PW, the Abdul Sahib. The custody of the above document is held to be proper because the above rent was paid by the Abdul Sahib as much as it is natural that the receipt would be with. Considering the fact that the exhibit 2 is a document which is 30 years old and is produced from proper custody, it is presumed that the same is executed by Abdul Ghani, the receipt of the rent for the suit. The learned counsel for the respondent has contended that the exhibit 2 does not contain the signature of Abdul Ghani. That was the same cannot be relied on. The above contention of the respondent is sustainable because the PW1 had specifically stated that the exhibit 2 was sent by Abdul Ghani, which means that he had executed the same the receipt of the rent, and merely because the signature of Abdul Ghani Sarkar is stated, the same would not make the exhibit 2 inadmissible. It is seen from the above that Abdul Ghani Sarkar had settled the above suit in favor of the plaintiff number 1, upon execution of the exhibit one, and further he had received the rent for the aforesaid suit done by execution of exhibit two. As such, the finding of the learned trial court to the effect that plaintiff had failed to afford the proof that they are the tenants under Appeal Kuni Sarkar is held to be erroneous and not based on the material suit. The contention of plaintiff that the suit land was settled in favor of plaintiff number one, the Appeal Kuni Sarkar, as a tenant, and that they had acquired a right of permanent tenants for passing of some temporary settled areas tenancy of Veterans Bank Road.
Now, what would be the position for land which were settled, which were transferred to RIT before coming into operation of the 71 Act? Here there's an observation that the initial transfer was in the year 1956.
Yes.
And the right to be recognized is only in accordance with the 71 Act.
Seven.
So how was that taken into consideration?
That observation is not there. Only their right of items was prepared in the year 1995.
On the basis of what?
On the basis of their possession.
No. There has to be a proceeding.
Proceed.
Proceeding under 71. That is the only act, Temporary Area Settlement Act 1971. You make an application under 23, fulfill the factors, get an ownership, recognition of the ownership. Now here it appears that the claim is from 1956-57, or I think 54. What was the date?
56, 57.
56-57. So how, from which the title relates to which act, which statute? The title which they are claiming is under which law? Because in paragraph 14.1, there is a clear observation which has been reproduced by the First Appellate Court that the plaintiff number one allegedly came into possession of the suit land as a riot under Abdul Ghani Sarkar way back in the year 1956-57.
Before 1971, there is an act, the Assam Temporary Settled District Tenancy Act 1930. That was there.
No. What was the procedure under that? Was any orders passed under the earlier statute?
The landlord even for the rights. There.
Now you see the observation at 14.1 at page 40. 40. I have perused the impugned judgment on case record. Have you got page 40?
Yes.
Internal page 8 of the. Please read, Mr.
trial of-
Chaudhary.
Yes, I have perused the impugned judgment and the case record. The perusal of the impugned judgment which said the learned trial court had ignored the
Pattanama exhibit 1. There
Yes.
was the exhibit by which the plaintiff number 1 allegedly came into possession of the suit land as a riot under Abdul Ghani way back in the year 1956-57. So undoubtedly it is before the 71 Act. So it might be under the earlier Act. But was there any proceeding for transfer of ownership or recognition of ownership of the riots?
ownership as it was we were in continuous possession since 2004 when they objected. So we'll come under 1971 Act. first.
No, but under the 71 Act, was there any proceeding drawn in which orders were passed in your favor? You are relating your right to a Pattanama of exhibit 1, which
Yes.
was 56-57.
1956.
That cannot be under this.
No one ever raised any objection regard to that purpose. No one never raised in regard to the position of the plaintiff. Only in 2003 when they objected, then their writing Katyan was cancelled. Lordship, their counterclaim is also typecast. The 1956 Pattanama was given and they raised objection in the year 2003 or there it is supposed to 1956 to 57. They are claiming that they are legal heirs of Abdul Ghani. So we are participants. That's about our position, about our right title in the only in the year 2004, but that was cancelled. 2004 state was there. Filed a petition that one Hamidul Islam, the defendant number 2, filed a petition on 8/12/2003. And exhibit 1 shows lordship in the year of 56. And here claim cited in the that it is not required by the company to stop for an search. And here claim cited on the basis of exhibit 1. Immediately their right title was out. Their right lordship, they are required to file counter claim, right title and revision. But their counter claim is only the basis that we are participating.
No, but we cannot go into the aspect of what should have been done. We have seen the counterclaim was only for eviction. That has also been dismissed. And they have not filed any cross objection or appeal,
Now
further
there is
appeal.
nothing, lordship. Even if my suit is dismissed, lordship, only the plaintiff will be affected. The defendants will not get it, as their prayer for recovery was not there.
That is what we are trying to
Lordship,
project to you, both of you.
Lordship,
What do you gain by now? See,
only
your
my
suit,
right title,
your
lordship.
suit as well as his counterclaim was dismissed.
I am
Y-
active. I am
You,
still active.
you came against dismissal of your suit to the first appeal.
Lordship,
First appeal allowed.
lordship,
The prayers in your suit has been decreed. And he is not aggrieved by dismissal of his counterclaim
lordship.
till now. Nothing has been filed. He is only aggrieved by the judgment of the
Decretal of
first
the-
appellate court, whereby your decree has been, your suit has been decreed. Now, even if we allow this,
You will not get- you
your
will not get it.
possession cannot be disturbed.
Only that my, I think here my here was cancelled, that will,
It will remain in the form of a cancel Khatian, but there will be nothing to affect your possession.
that position would be.
No, that is okay. That is okay. But
And there is
practically
no
you are
pur-
gaining nothing.
And in fact, lordship, there is no perversity. The first appellate court discussed everything.
Mr. Chaudhary, what practical, what would be the fruit you'll be getting if you allow the appeal? Suppose you make out a case where your appeal is to be allowed. You will not get anything.
Okay. Because I have not prepared any appeal against the counter claim, dismissal of the counter.
Because
And in that
the
case-
question of their eviction, which was the subject matter of your counterclaim, that has been rejected and that has attained finality. And this appeal of yours is only of the first appellate court's order whereby their suit has been decreed.
Yes.
The challenge to the Pattannama, which you made in the counterclaim, that has been rejected.
For lordship, the appeal was admitted on court state maybe on the ground that the substantial question of law, whether the issue numbers 1, 6, and 7 by first
On
appellate court-
4, 6, 18, three substantial questions of law were framed.
first one, lordship.
4, 6, the order is a 4, 6, we have noted. 4, 6, isn't it?
Yes.
Yes,
4,
4,
6,
6. Yes, please, first one,
Whether the issue numbers 1, 6, and 7
reversal.
by first appellate court with respect to the findings of learned trial court are proper. That is one of the question.
Yes, that is.
And-
What are issue numbers 1, 6, and 7? Let us know.
1, 6 is
Issues we have
One is whether the plaintiffs have right title interest and possession over the land.
Issue
and
there,
the
page 38.
Yes, sir.
Page 20 issues are there.
38 is also same
Yes.
issue. One, 6 and 7.
1-6 is
What is
correct.
one?
1-6 is correct. 7, your lordship will find whether the defendant's counterclaimants are entitled to get first possession of B schedule land. This point cannot be a substantial question.
No, this could not have been an issue
Yes.
in the appellate
In
court.
the
No,
regular,
in the appellate court
Yes.
also.
even lordship, the
Because
appellate
the first trial court had framed the issues which were common to the suit as well as the counterclaim. So, 6 was one of the issues. Now the counterclaim having been dismissed and there being no cross appeal, 6
is
could
not-
not have been one of the issues.
It is not required by the even first appellate court
That
to
is it.
discuss the issue number.
First appellate court, before the first appellate court, this should not have been an issue. Okay. And even 7,
7.
6 and 7 both.
So their first substantial question of law will be first. Only in regard to issue number 1, they are required to
Whether
say.
the reversal of. Now, how did the first appellate court decide issue number 7?
First appellate court decided by formulating point.
No, issue number 7.
No separate discussion issue number 7. The lordship will find the first appellate court formulated one point.
But
That is it.
paragraph 33, madam.
Page 39,
Paragraph 33,
33,
page 50.
in view of the above discussion. More particularly, the decisions raised in the issue numbers 1, 6, and 7. It is held that the learned trial court had erred in deciding the issue number 2 and 8 as the decision of the learned trial court in the issue number 2 and 8 are settled. It is held that the plaintiffs have right title interest possession over the schedule B land. It is further held that the cancellation of the names of the plaintiff and so is illegal liable to be set aside and the revenue records be correct. There was no discussion with regard to a cross repeat lordship in paragraph 31. On the perusal of the impugned judgment reveals that the learned trial court had dismissed the counterclaim filed by the defendant number 1 to 4 and further decided the issue number 3, 4, and 5 against them. But the defendant number 1 to 4 had not filed any separate appeal or cross-objection appeal. As such, the above issues are not required to be decided after the same are not challenged by any of the parties.
Correct. This is correct.
If first appellate court also not decided contract, as there was no. These,
But then if that is the position, then the first question of law which has been framed,
only issue number 1 they cannot. 6, 7 they cannot ask.
there was no reversal. Was there a reversal?
What is
No, the substantial question number 1.
what?
The substantial question number 1 in the order dated 4/6/2018. Whether the reversal of issue numbers 1, 6, and 7 by the first appellate court with respect to the findings are proper.
Lordship, there was no reversal.
There was no reversal.
Only that word was there, Lordship, in regard to issue number 167, paragraph 33.
No, that is not, that will be a
The- no,
perverse finding,
Yes,
with all respects. Paragraph 33, Mr. Chaudhary,
Yes, sir.
in view of the above discussion, more particular discussions reached in issues numbers 1, 6, and 7, it is held that the learned trial court had erred in deciding 2 and 8.
Yes.
It has nothing to do with 1, 6, and 7.
So, Lordship, the first substantial question of law is
Yes,
not a substantial question of law. And second one, whether the findings of first appellate court in regard to exhibit 2 and draws the presumption. Section
But if your entire case is dependent on exhibit 1 rather than exhibit 2, that question would not be relevant, I think. If the Pantannama is not the further subject of challenge, after then whether the rent receipt will have any relevance.
But the
Pantannama
that
has
the
been
right
issued.
way to-
Pantannama issued as exhibit and approved as exhibit 1. The factors which led to the issuance of Pantannama, namely the rent receipt, will not have any relevance. And third one,
is the part.
whether the Khatiyans relied by the plaintiff respondent can be taken into consideration for first appellate court after its cancellation by the revenue authority, and the same having not been restored back.
that is the Lordship issue for which the plaintiff filed
Filed a suit.
this substantial question of law is also not a it is the duty of the defendant to prefer appeal against counter rather than appeal against. They ought to have filed the appeal against counter.
Mr. Chaudhary, you must have framed this while in assisting the court. You have not framed it correctly. No, no. Paragraph page 4. I don't think there was any error on the part of the council.
Yes,
No, even there was no error. Come to page 4. I think the questions of law framed, I think those were, I think, more or less proper, at least deserves an adjudication. Page 4 of the memo appeal.
Whether exhibit 1 is counter number.
These are okay. Unfortunately, these were not framed. I don't think these are out of the context. This can be held to be relevant.
Exhibit 1.
Exhibit 1, 2, 3.
Presumption was wrong.
Yes,
That
at
can
least
be a question of
these are not whether these questions are decided in his favor or not, that's a different matter. But this may require an adjudication process.
But
But
Lordship, his appeal was admitted only on the three substantive law formulated on
4/6/2018. Now, we were considering the aspect whether these 3 questions were suggested by the appellant. These were not suggested by him.
at the time when counsel, the appellate was present. In this presence, where
What will your counsel do?
Lordship case, they have nothing. Not preferred in challenge their counsel.
But the substantial question of law number 1, which was framed by them to assess the court, I think this will have a relevance.
In this
Presumption of 30 years
Lordship,
under Section 90 of the Evidence Act. We'll have this tomorrow again. Let me have a look. You also,
In response to section 19, I have got some,
on the presumption part.
yes.
Okay.
One lordship 1996 8
Mr. Chaudhary, there will be some, what do you say, disadvantage on your part. Though there is an observation that any other substantial questions of law, but without giving all the parties an equal opportunity to answer to substantial questions of law, mainly to the defendants. The notice is issued on to answer on this. Now, if we take a substantial, if we frame a question of law at the time of hearing and answer immediately, that may not be proper. And this is an appeal of 2000 RSA of 2018. Title suit is of the year 2000 and which suit was of which year?
2005,
2005. We are not adjourning matters of this nature.
already quit. Almost.
Another presumption will be drawn now. We'll continue this tomorrow. You come prepared with the facts again. We'll continue. I think some things, some more facts. Okay. Tomorrow you're okay? It's okay?
At 2.
Maybe at 2. But we'll not say anything in the order. We'll have it tomorrow, but we'll have it at 2 o'clock. List for consideration again tomorrow. Okay.
Yes.
Yes. You said there are some MSc matters. If there is a small matter, we can finish today. 18-9. Small matters.
Small.
It's very deceptive when lawyers
Yes, lawyers say it is
say
small.
small. Very small is more deceptive.
Maintainability
of the claim. Also, I'm the tip.
In an appeal.
Lordship, this is the appeal is filed by the insurance
Insurance
company.
company is the appellant. What is the
And the
problem?
second one, they have filed. Lordship,
We have filed for enhancement, they have filed the cross
Okay.
appeal.
no, not cross appeal. Ours is an appeal. We have filed that
Separate
the-
appeal.
Huh?
Separate
Separate
appeal for
appeal. That-
enhancement.
the compensation granted 4 lakhs of compensation, which is not maintainable. That's what we have filed for. And they want some enhancement.
Okay.
Lordship, without going into details of the case, without going into the
You are the insurance company.
Yes.
You are along in the same party,
same,
but
same
in
insurance.
the respondent, you are representing the company. Okay. In the appeal filed by them.
Yes.
Okay.
Without going into the detail of the case, Lordship, I'll just mention a few facts. There was an accident wherein a vehicle number AS21C 0779 truck insured with the appellant company met with an accident with vehicle number AS01BF 8788
AS01?
BF 8788.
Two vehicles were in.
2 vehicles were
The
involved.
second one is also a truck.
No, it is a Ford EcoSport. The respondent here, claimants, they claimed the claim case was filed for damages to that vehicle. That extent only, no injury, or they did not claim any.
Which vehicle? EcoSport.
Sport, yes, EcoSport.
Yes.
Then, Lordship, their allegation was that due to the accident, that his Ford EcoSport was completely damaged and beyond repair. They submitted estimate for repair, not the repair thing, but just estimate. That estimate was given for rupees 8,75,658. Now, Lordship, the most important part here will be evidence cross-examination of PW1 that Lordship will find at page 22 of the LCR. So we have to be clear
Yes,
that the case was filed for damage to the vehicle, And in his evidence in affidavit as well as in cross-examination, the claimant accepted that he has already sold the vehicle. Sold the vehicle means from his insurance, Tata AIG, he has received the amount. Ultimately said.
Now, vehicle was insured by
By Tata AIG. His vehicle was Tata. This truck was insured with us, Oriental Insurance, and the Ford EcoSport, claimant's vehicle, was
Tata AIG.
Tata AIG.
And he had made a claim
There.
with Tata.
And settled also. And in his evidence as well as in his cross,
Oh, yes.
he accepted that his vehicle was, he had already sold the vehicle to Tata and received the amount, 3 lakh something. Court has said something.
Sold it, sold means, so I sold.
Because sold in the sense, Lordship, the damaged vehicle was because it had a policy with Tata AIG, own damage claim.
Yes.
So he claimed that own damage from the, and after claiming, without disclosing that, the claim petition was filed claiming that same damage amount from the Oriental Insurance.
But
From the
you
insurer
said that in the evidence it has been disclosed.
Yes, he disclosed it.
So where is
No,
it?
no, in the claim petition, he did not disclose that. It is
In the evidence.
in the evidence. In the claim petition, he filed the claim petition as if he is filing a claim for the damage to the vehicle, and the estimate of damage was 8 lakh, 8,75,700.
Okay.
So, but in cross-examination, Lordship will find at page 32 of LCR. I'll read just, I have noted down. My vehicle was insured at the time of accident with Tata AIG Insurance Company. I have already received the own damage claim lodged with the above mentioned company. I have filed this case only for my property damage and other related expenses. I have filed this claim petition after disposing of the scrap of the vehicle. This case is filed for repair of the vehicle, but already the vehicle is sold as scrap with the Tata AIG and he has got. So what are they going to repair? Why the compensation to repair losses? Which vehicle are they going to repair? That is the moot question here. That is to be decided. That's why we have filed this appeal. And I'll read some part of the judgment, Lordship, where even the court.
Yes, can you make double insurance?
Yes, that is.
Lordship, that's a complete.
No, we have all more or less.
This is not that particular case of double entity.
Yeah.
Why I'll come to that. There are a series of judgments on this particular. Now the relationship which the claimant had with his own insurer, there a comprehensive insurance package was of a contractual level.
Yes.
And here the claim which the claimant has actually placed before the MSCP tribunal was of a torture. Both of them are on a separate plan. Because for the comprehensive insurance package, he has paid a premium for it. And because of his foresight, because if something tomorrow happens, then he will be compensated. Now, with regards to the liability of the.
Now, was it a third party claim with your insurer?
No, it's a comprehensive insurance policy for which a premium was.
Understood, but was it a third party claim? That somebody had claimed from you, so your liability has been taken care of by the insurer?
On that particular issue itself, the Honorable Supreme Court has said that both of them are on separate things. I'll come to that particular judgment.
Please show us the judgment.
Here. That's the judgment of the LNC Robelo judgment.
Yes, let us. We have read Robelo. Let us read again.
Yes. I'll start from paragraph number 2, the question which was involved.
Yes, citation.
Your Lordship, the judgment is there in the record.
Just a minute, please.
as a lordship. But
Yes, yes.
if I may take your lordship to paragraph number 2, first page itself, the question is
Hmm.
whether the life insurance money of the deceased is to be deducted from the claimant's compensation receivable under Motor Vehicles Act 1939, the minimum metrics of the fact to appreciate the controversy stated as under.
Hmm.
Therein, if I may take your lordship, in that particular case, the money which she had actually received from the life insurance company for which she had paid a premium was deducted from the claimant, stating that both the claim amount form part of one particular claim. So on the Supreme Court, if the lordship may then go to para number 38 and
Are you
40,
trying to equate a life insurance
No.
and a
not only life insurance,
insurance, general insurance?
not only life insurance, Your Lordship,
Then?
the question is for which a premium is paid. For which a premium is. I'll come to your lordship. If your lordship comes to paragraph number 38. This is based on the principle that the claimant for the happening of the same incident may not gain twice from two sources. This is the main gamut of this whole controversy.
30,
Paragraph number 38.
38.
38.
Yes.
This is based on the principle that the claimant for the happening of the same incident may not gain twice from two sources. It is excluded thus either through the wisdom of legislature or through the principles of loss and gain through deduction, not to give gain to the claimant twice, arising from the same transaction, namely same accident. It is significant to record here in both the sources, that is either under the Motor Vehicles Act or from the employer. The compensation receivable by the claimant is either statutory or to the security of the employer securing for his employee. But in both cases, he receives the amount without his contribution.
Okay.
How does an amount earned out of one's labor or contribution towards one's wealth, savings, etc., either for himself or for his family, which such person knows, under the law has to go to his heirs after his death, either by succession or under a will, could be said to be the pecuniary gain only on account of one's accidental death. This, of course, is a pecuniary gain, but how this is equitable or could be balanced out of the amount to be received as compensation under the Motor Vehicles Act? There is no correlation between the two amounts, not even remote. How can an amount of loss and gain of one contract would be made applicable to the loss and gain of another contract? Similarly, how an amount receivable under a statute has any correlation with any amount earned by an individual. Principle of loss and gain has to be on the same place within the same sphere, of course, subject to the contract to the contrary or any provision of law. Paragraph number 39 is important here. Broadly, we may examine the receipt of the provident fund, which is the deferred payment out of the contribution made by an employee during the tenure of his service. Such employee or his heirs are entitled to receive this amount irrespective of the accidental death. This amount is secured, is certain to have been received, while the amount under the Motor Vehicle Act is uncertain and is receivable only on the happening of the event, that is accident, which may not take place at all. Similarly, family pension is also earned by an employee for the benefit of his employee in the form of his contribution in the service in the terms of the service conditions received by the heirs after his death. The heirs receive family pension even otherwise than the accidental death. No correlation between the two. Similarly, life insurance policy is received either by the insured or the heirs of the insured on account of the contract with the insurer. I am stressing on this particular point. Contract with the insurer for which insured contributes in the form of premium. It is receivable even by the insured if he lives till maturity after paying all the premiums. In the case of death, insurer indemnifies to pay the sum to the heirs, again in terms of the contract for the premium paid. Again, this amount is receivable by the claimant not on account of any accidental death, but otherwise on insured's death. That is only a step of contingency in terms of the contract to receive the amount. Similarly, any cash, bank balance, shares, fixed deposits, etc., though they are all pecuniary advantage receivable by the heirs on account of one's death, but all of these have no correlation with the amount receivable under a statute occasion only on account of accidental death. How could such an amount come within the periphery of the Motor Vehicles Act to become a pecuniary advantage liable for deduction? When we seek the principle of loss and gain, it has to be on similar and same plane, having nexus inter se between them, and not to which there is no semblance of any correlation. The insured contributes his own money for which he receives the amount has no correlation to the compensation computed as against tortfeasor for his negligence on account of the accident. Now, negligence, they are not on that particular issue, that there is no negligence on the part of the driver of the offending vehicle. That is proved beyond doubt. They are not challenging on that ground in this particular. So we may leave that out. Now, as aforesaid, the amount receivable as compensation under the Act is on account of the injury or death without making any contribution towards it. Then how can fruits of an amount received through contributions of the insured be deducted out of the amount receivable under the Motor Vehicles Act? The amount under this Act he receives without any contribution. As we have said, the compensation payable under the Motor Vehicles Act is statutory, while the amount receivable under life insurance policy is contractual. Then this particular judgment was followed in the Patricia Jean Mahajan case, wherein at paragraph number 33, 34, and 35, if I may take your lordship, I'll take your lordship straight away.
But ultimately, the decision that you have sold the vehicle as scrap.
Yes, no, your lordship. I'm
Now,
not sold
now
the
what is the
vehicle.
amount you are
Your
requiring
lordship,
for?
If I may state the correct fact, your lordship. Your lordship, the claimant's vehicle was being driven by his son. It was going in a particular direction. The offending vehicle, a truck carrying sand, it entered the highway from the left-hand side at night without a headlight on. And that.
No, we are not on those. We are not, we are not on the negligence part. We are not on the negligence part. It is not a
Very well.
claim
Very
for
well.
any accidental injuries or anything sustained by the person. It is for the vehicle.
Very well.
It is for the vehicle. Vehicle is admittedly sold as scrap.
Ultimately, your lordship, if I may.
Please have the patience.
Yes.
And prior to that, the insurance amount, which was maybe a part of the contract with your insurance company, you have received the amount. And now the vehicle has also gone from your hand. Now the amount which you are claiming is for repair of the vehicle.
To make good the loss, your lordship.
That is different aspect. That is not for repair of the vehicle.
Because if I may come to your lordship, the vehicle which was insured with the company, it was insured for a particular sum insured only. I have annexed the exhibit, your lordship. If your lordship may go to the exhibit, which is the estimate, which came to around 8,78,000. Now, the Honorable Tribunal, they said that the surveyor's report could not be annexed with that particular claim. Surveyor's report of the insurance company with whom I had a contract of insurance with. That could not be annexed. Therefore, that particular compensation amount, the damage to the vehicle could not be. But that is the surveyor's report, your lordship, is the private document between the insurance company and their own surveyor. That I am not aware of. That I cannot get hold of, your lordship, because the surveyor will submit that particular surveyor's report with the insurance company. Now, that for that particular insured, the contract which I had with my own insured, that was a contractual liability with the insurance company, Tata AI, and for which they have actually fulfilled their contractual obligation, and they have paid a particular sum of insured. And since the vehicle was totally damaged, the insurance company said that this is totally damaged, we will not be able to cover it. So this will be treated as total damage, and we will take over the vehicle. It is not for me to sell that vehicle, because it was insured with a particular insurance company, Tata AI. I have not sold the vehicle. They have taken over that particular vehicle, and they have paid only a scrap value of 20,000 rupees. A Ford EcoSport vehicle, a new Ford EcoSport vehicle, for which they have paid the sum insured of 3,53,000 plus 20,000 as scrap value. And the new Ford EcoSport vehicle, the estimate of which came to around 8,78,000, to restore it to the original condition as it was. That particular amount has to be.
We don't find bona fide on your part, Mr. Counsel. I think it's a case where we have to impose cost upon you.
Your lordship, if I may
Heavy
place
cost.
your lordship, if I may place the judgment
Heavy
of the-
cost.
No, your lordship.
We have heard you.
If I may place
We don't
the
find any
particular-
bona fide, sorry.
If I may place one judgment.
You
of
cannot
similar-
misuse public money like this.
Your lordship, I'm not excuse it.
Sorry for interrupting you.
Your lordship,
The,
this particular judgment, your lordship.
the tenor which you are adopting in this kind of matters and filing of a cross appeal itself, I think it's a audacity.
Your lordship, that
Sorry.
we have to make good that particular.
We
original
will see
position,
what
your
is
lordship.
to make good, we'll see.
Your lordship,
If
my
you want to make
vehicle was
submissions,
totally
you can make
damaged, your lordship.
submissions for one whole day, but we're going to impose heavy cost upon you.
Your lordship, the.
You are
vehicle-
misusing public money.
Your lordship, the vehicle was not damaged due to my fault, your lordship. It was damaged due to the.
What was
negligence of
the
offending vehicle.
claim for? Was it for any injuries or deaths? No.
No. It
The,
is for restoring
the claim was for the vehicle damage,
property damage.
property damage. If you
Yes.
have got the damage, how can you approach this tribunal?
Property damage.
And you have not disclosed that you have got the money from your own insurance.
No, I will disclose at the time, evidence, your
Oh, that
lordship.
is in the evidence, cross-examination.
Yes,
Is that a
your
disclosure?
lordship.
You are a
that was-
seasoned counsel, Mr. Bora.
your
Is that a
lordship,
disclosure?
your
Have
lordship,
you approached the tribunal with clean hands?
because
Of
the
course
format-
not.
The format of that particular claim tribunal
Sorry.
application itself doesn't mention any such.
No, they
column,
can
your
mention.
lordship.
At the end of the year, facts of the case is to be mentioned.
That is
have
not
mentioned
mentioned,
here.
your lordship.
They have given 2 pages of that, but they have not mentioned that.
Sorry, Mr. Bora.
Your lordship, if I may place one judgment of the
Please,
Honorable
please,
Division Bench
please,
of the
Please do, please,
Mumbai High Court, your lordship,
do.
on a similar line. Your
please
lordship.
do. Rebello is under entirely different concept.
Your lordship,
You're trying to bring in Rebello. We have read hundreds of times.
your
And
lordship,
there are how many cases we do not know? Even a claim under the Motor Vehicles Act and one under some other contract, those have been also equated.
Yes.
These all amounts to public money.
Yes.
Your
I have
lordship,
that judgment.
public money, but for which I have paid a premium. That's a different claim, your lordship. That's on a contractual liability claim. And this is on a
Premium, why? Because of contingency.
contingency, your lordship.
It's a contingency premium. What is the meaning of a contingency?
But that is not absorbed amount of liability, your lordship. Tortuous liability is there.
The contract is to indemnify if there is a third party claim upon you. And if your vehicle suffers a damage, your vehicle suffers damage, you have been indemnified. Then how do you make a claim on another vehicle?
Your lordship, section 147 of the MST Motor Vehicles Act makes it compulsory to have at least a third party insurance, your lordship, not comprehensive insurance. Comprehensive insurance are paid an extra premium for it, your lordship.
Comprehensive, what is the meaning of comprehensive? What is the meaning of an act policy? Just let us explain.
A third party insurance, your lordship.
What is a comprehensive policy? What is an act policy?
Comprehensive policy, your
Yes.
lordship, it covers my own damage as well as.
Own
third party
damage, when
liability.
you suffered a damage on your
Yes.
body.
Yes, your lordship. And for which
It
I have
doesn't
a
make any
premium.
difference whether it's a comprehensive policy, when the vehicle suffers a damage, you get the amount.
For
The
which I have paid a-
comprehensive policy will cover your body.
Your lordship, that would actually mean that they would go to spot free and that
No, but
offending
it's not a
driver.
Question of going scot-free, whether you have been indemnified or not, whether you have suffered the
Yes.
loss suffered, whether they have indemnified the loss or not, to the extent possible.
My own insurance company.
Yes.
Your lordship, but for to it to restore it to
It's not
that
a-
original
you-
condition, your
It's
lordship.
not a question of going scot-free. You file a case, a criminal case, prosecute them for the negligence. You said this is a tortious liability, it's a civil liability.
Your lordship,
Can you have civil liabilities settled on parties after getting the compensation? You proceed against them as per law criminally. But how do you get?
your lordship.
Don't you think it's a double gain
No,
of a
your
public
lordship,
money?
because I'm relying on this particular
Apex
judgment of
Court
the Honorable
judgment
Supreme Court.
passed this year, February, lordship, February. He's relying on Helen Rebello. That was discussed in this. And the Apex Court said that in our view, there cannot be a duplication in payment or a windfall owing to a misfortune. That same judgment, the Apex Court has dismissed.
I'm not making any windfall claim, your lordship. Your lordship, I am on a.
Bora, the entire law of insurance, as you know, is utmost good faith.
Hmm.
Where is your disclosure in making a claim? You say something only in the cross-examination. Why don't you disclose that I have got the money, but still I claim? Where is your good faith? Utmost good faith.
Lordship,
It
maybe
lacks.
that could have actually.
It's an
been made for-
insurance.
because-
Insurance. We are adjudging an insurance claim.
But your lordship, at the same time,
You disclose everything. Then if you get, you get. If you do not get, you do not get.
your lordship, motor vehicle claim is based on tortious liability, your lordship.
But tortious liability, isn't it isn't it based on an insurance policy of insurance?
Yes, it is based on a policy of insurance.
You are
but-
making a claim, you're saying that something has happened, therefore I'm entitled to it. Aren't you required to disclose the entire facts?
Lordship, I
And
believe-
moreover,
I
lordship,
believe
what
in good
vehicle,
faith, I have
like,
actually
still,
disclosed the facts, your lordship.
still my learned
Depending
friend
on-
is
depending
submitting
on
that
the-
they have to repair something. What are they going to repair, lordship? What are they going to repair?
Your Lordship,
Already
if I
the
had to
vehicle is
repair it,
gone.
Your Lordship,
This
I had to
case is
pay from my
minor.
own pocket, which I didn't have the money to
If I
actually
had
restore it
to,
to the
if I
original,
had to repair, Lordship,
original position, Your Lordship, 8,78,000 was required. I didn't have that amount of money to
And,
restore it.
the entire vehicle was damaged. You said they had paid a paltry sum of 20,000.
1,000.
What was the compulsory part on your to dispose of the vehicle? You said you could have said, I am not going to give him
Your
20,000.
Lordship,
Yes,
What
kindly,
will happen?
he
Will
had the
happen.
Your Lordship, may kindly,
I'll have my chance in the tribunal.
Yes,
Your Lordship,
exactly.
Your Lordship may kindly go to one exhibit, Your Lordship, just the exhibit of the particular
Yes, which-
vehicle, the
which-
damaged vehicle. Your Lordship.
But yes, Lordship.
Actually,
Just one by one.
I have given of the same case.
No, this is Kerala, I'm
on a-
giving Apex Court.
Anyway,
That
but same to
Mane-
same case.
Your
double
Lordship may kindly
duplication
go to
of-
exhibit number 2, Your Lordship. The damaged vehicle, whether it is recoverable, Your Lordship can only
We'll not
determine.
go to the factual aspects. We'll stick
Yes.
to the point of law. Yes. Which one, Krishna?
Yes, Lordship, mine is Krishna and others. Here in this case, actually, Lordship, what happened, they got compensation for something and again they claim, but double ye should not be
Don't be.
given. That is what.
Either,
Apex Court
either
said.
insurance, either party.
No, No, it was income or upara. This is regarding income, Lordship. They-
Cannot be reduced in terms of.
Which point?
There's no. No traffic accident further under the provisions of this.
But
Oh,
but it income or
the
case or
benefit is-
double
cannot be-
benefit or like
cannot be a application.
MFA.
And there was on the death of a person. This has gone to some different extent, Mr. Bora, if you look at this. The scheme under which the compensation was paid was a dying in harness scheme of a government servant. But the death was because of a road traffic accident. Even in that case,
Your Lordship,
even in that case, you are talking about tortious liability and
if Your Lordship may kindly take up this
how
case,
do you equate a dying in harness scheme and a road traffic? Can it be equated?
Your Lordship,
You cannot, but still then, after discussing everything, it has been held to a duplication of payments of windfall owing to a misfortune.
Your Lordship.
The court has even Honorable Supreme Court has gone to the extent that if the death was because of some illness or other reasons, then matter would have been different. But if the death is because of a traffic accident and you get compensation because of such death from the state government, you cannot make another claim.
Your Lordship, if I may take Your Lordship. to
And
just-
you are on the aspect of the property damage.
Your Lordship, if I may take Your Lordship to this case of Sebastian Lacra. It
Yes.
is there, Your Lordship.
Sebastian Recca is also mentioned here.
And if I may.
In the
take Your
judgment I
Lordship,
have given, Lordship,
please,
paragraph
if I
4,
may- If I may just state.
paragraph 4 it is discussed.
If I may state my,
2019-17 SCC.
Sebastian Lacra,
Yes.
yes, Your Lordship, 1917, 465.
It's,
There, if Your Lordship, if I may take Your Lordship,
that has been discussed in Krishna.
Your Lordship,
This is of 5th of February 2024.
Sebastian
Yeah.
Lacra was basically
They
on the
submitted
premium
for a
part, Your
district
Lordship.
judgment 2024.
Your Lordship, maybe that may be on the part of dying harness scheme, Your Lordship, but Sebastian harness was on insurance part and the premium payment
No,
part.
see
which
the
I am-
extent of the Honorable Supreme Court has gone into. Even a scheme for dying in harness has been equated with the money involved in an insurance claim. It had to be duplication.
Your Lordship, if I may take Your Lordship to one line, Your Lordship, just one line of Sebastian Leclerc.
may not be relied on. You see, this judgment was passed this year.
Let us have a look. Sebastian Leclerc. Yes, please.
If I may
Paragraph?
take your lordship to paragraph number 13.
1-3.
13.
1-3.
Yes. As far as any amount paid under any insurance policy is concerned, whatever is added to the estate of the deceased or his dependents is not because of the death of the deceased.
Paragraph 13.
13, your lordship.
Just a minute, please.
As far as any amount paid under any insurance policy is concerned, that particular paragraph.
Just a minute, please. One, three. Yes, please.
As far as any amount paid under any insurance policy is concerned, whatever is added to the estate of the deceased or his dependents is not because of the death of the deceased, but because of the contract entered into between the deceased and the insurance company from where he took out the policy. The deceased paid premium on such life insurance, and this amount would have accrued to the estate of the deceased either on maturity of the policy or on his death, whatever may be the manner of his death. These amounts are paid because the deceased has wisely invested in his savings. Similarly, would be the position in case of other investments like bank deposits, shares, debentures, etc. The tortfeasor cannot take advantage of the foresight and wise financial investments made by the deceased. Then, if I may take your lordship to the paragraph number 15, your lordship, as held by the House of Lords in Perry versus Cleaver, 1969 ACJ, the insurance amount is the fruit of premium paid in the past. Pension is the fruit of services already rendered, and the wrongdoer should not be given benefit of the same by deducting it from the damages assessed. The deduction can be ordered only when the tortfeasor satisfies the court that the amount has accrued to the claimant only on account of the death of the deceased in a motor vehicle accident. And in fact, if I may actually, as I try to place reliance on the on a very similar factual situation of the Honorable Bombay High Court, your lordship, wherein
The comparison was, in this case, was compensation on account of accident and compensation on account of pensionary benefits and other gratuity. How can you correlate these two? If there is some negligence in payment of compensation, in payment of pension, gratuity, it will be taken care of, but it cannot be linked with the money which is the subject matter of an insurance. Here it's out and out, both the amount claims are because of an accident insurance amount.
the lordship, my line of argument is basically because of the premium paid, that extra premium I paid, in addition to the statutory liability of having a third-party insurance, lordship, for which I paid an extra premium.
If the amount was denied by your insurer, matter would have been totally different.
That would have been.
That
totally
would have been
different.
a subject matter of adjudication, very correctly. Your matter has not been denied by your insurance.
But the value of
Now
the
you are
vehicle, your lordship,
seeking a damage from the truck. You could have rightly done if there was something else. Unfortunately, there was nothing else, only vehicle damage to the vehicle was done. So we are not on those aspects. But for repair, for damage to the vehicle, if you are already been indemnified by your own insurance company, can you seek another amount from the offending, so-called offending vehicle? The offending vehicle will face its own consequence in a criminal case, which perhaps is going on. We do not know.
but would that actually absolve the tortious liability, your lordship? Would that absolve the driver of the
It is
offending
not a
vehicle?
question of absolved from the tortious liability.
Because
You go against them. You've already gone against them in a criminal case.
both motor vehicle accident cases and criminal cases, they are not two different things. That is my humble submission, your lordship.
Mr. Paul, you'll have your chance if you speak in chorus. How can we concentrate? Whom to listen? Have we precluded you from hearing or said that we'll not hear you? We'll hear you, don't worry.
I try to place one judgment on Bombay High Court Indian bench, your lordship. Has
2019. 17 SCC. Now, what has the tribunal done? How much, tribunal has granted some amount?
Yes, 4 lakhs, Lordship. And tribunal also had its own doubt, but still, Lordship, I'll read my memo of appeal, page 10 and internal page 5 of the judgment, Lordship. Lordship will come to the third last paragraph. Second last.
What was the
Exhibit six.
basis, what is the basis of the grant?
No basis, Lordship. That's why I'm reading from
Lordship,
that
they
second
could
last.
not
Exhibit 6.
Use any evidence or counter this particular fact before the tribunal also. And the tribunal has rightfully.
Page 10 of a memo of appeal or internal page 5 of judgment, Lordship.
Yes,
The second last paragraph. Exhibit 6, Lordship. Got?
yes.
Exhibit 6 is the estimate for repairing the vehicle, which shows that an estimate for an amount of rupees 8,75,000 something has been submitted by the MSCI Motors Private Limited for repairing the vehicle, but they have not filed any other document except estimate for repairing cost of vehicle bearing number so and so. Admittedly, an amount of rupees 4 lakh has been received by the claimant as own damage. Hence, in my opinion, if some amount is awarded for damage of FORR case to be paid by the OP1, it will be just and reasonable amount. So that is totally
Lordship, just one
beyond.
paragraph above this particular paragraph. Just one paragraph.
Just a minute, please. And did you make your own insurance party here?
No.
No.
If you are aggrieved by the adequacy of the amount given by your own insurance, Tata IIG, you make them a party, get the entire amount of 8 lakhs.
Lordship,
But Lordship, this is
generally
just
in this
estimate.
kind of, motor
This is
accident
just
cases, always the offending vehicles insurance company is.
Then why did you make a claim with your own AIG? It was entertained, paid. They could have very well said that we are not going to, this is not our.
Lordship,
You think insurance company, your insurance company's contract to indemnify you is only when there is a claim upon you. That is the contract of indemnifying, contract of insurance. If there is any, you need to face any claim, I am there to indemnify you.
yes, only
Now the claim is by you upon you.
that is as per section.
The insurance company would have very well said, no, we are not going to pay this.
Yes.
You file a case against them.
But-
And if you did, they entertained, they paid 4 lakhs, you file an application. 4 lakhs is not enough. But how can you come against a separate insurance company,
Your
which
Lord-
is the insurer of another vehicle, when you have got an amount from your own insurance company?
to restore that vehicle to its original condition, your lordship, the estimate that was given, that was proved, and they could not rebut
Okay,
it.
okay,
And that was actually
we have heard.
Observe, your lordship.
We don't need to
Well,
rebut
well,
this.
heard
Rebut
you,
that
we have heard
particular amount, your lordship, 8,78,000 to restore it to the original condition. Only 4 lakhs was actually given, your lordship. 3,53,000 plus 20,000.
You are not aggrieved. You are not aggrieved. Are you aggrieved?
Your lordship, for any insurance.
Now, are you aggrieved?
Agree with regards to my own.
Adequacy of your own insurance?
Your lordship, I'm not.
You are not aggrieved.
Yes.
Matter ends there.
Your lordship.
If you are aggrieved, you come up.
Your lordship,
We'll adjudicate.
comprehensive insurance policy package, the ITV of a vehicle is actually declared, your lordship, at the time of, and depending on the ITV, the premium is paid. To lower my premium, your lordship, the ITV was lowered, your lordship, to the lowest possible amount.
Okay, anything else?
Your lordship, I just want to submit that this will actually set a very bad precedence for any future accident cases. Because tomorrow everybody will hit somebody, then say that you have got your own insurance.
Are you in a public interest litigation?
No, your lordship.
Please don't make kind of submission.
Right.
We'll set a precedent in this case. Rest
But-
assured.
Your lordship makes not impose.
We will set a precedent in this case.
Your
If
lordship,
you are
I
insisting,
humbly beseech your lordship not to impose it.
if you are insisting, we'll think over. Yes, Mr. Pal. You have time of 10 minutes.
Not 10 minutes. My lord,
How many? 2 minutes. Okay, very good.
my lord, it's the case of first it said there's a suppress the material fact. So
No, no, what is, we have discussed, you need not repeat.
it is actually my knock it off. Either the fact.
Okay, tell us one thing. In the element of suppression, okay, in the claim petition, it was not disclosed. Was it disclosed in the chief examination?
Second.
In the chief?
Yes.
Chief examination or cross examination? Chief, there was a,
Because the investigator in the meantime went, lordship, so he found out that already that amount, our investigator
That
investigated
is
and
will
he
come to
found
know.
out.
Thereafter will come. Yes. Yes, already got done and it's set a final.
but
So-
before the cross, it was already
No,
placed
He has
before.
not mentioned
No, in the chief.
the chief, he has not mentioned in the chief. He has mentioned in the cross examination.
Let us see.
And at the court also.
Let us see that part. It may not be suppression. It may not be suppression per se. Let us see.
Internal page mode of the judgment.
Page 8. Okay, just a minute. Evidence on affidavit.
Yes.
I don't think it was disclosed in the chief examination also.
But it-
Cross page
Lord, page-
32, page 32 of LCR.
That is.
Oh, your lordship, it was never disclosed in a chief. That is my acceptance. Lordship, I have accepted.
Page
Because
32,
my line of
lordship.
thinking was somewhat different.
My vehicle was insured at the time of accident with Tata AIG. I have already received the own damage claim loan
Cross ex-
only for property damage and other related. I have after disposing of the scrap of the vehicle. Okay. Yes, what do you, Mr. Pal, what,
Yes, my lord, that is for.
of
That is for-
judgment? Yes,
Take the photo.
My lord, his epic, my assistant epic. That is for 30.
yes,
That is the four. That
Yes.
is just first step. The process that his vehicle was stopped at the time of incident. At a has already received the own damage claim house in the above pension company. He has stated that he has filed his case only after property damage and other related expenditure. He admitted that he has filed his claim after for the step of the that means after getting all the settlement money, then he has yes.
Which is file in 16 into
14. In between it is set.
in 15, 15, because estimate is of
what has happened to the criminal case? Any item,
Criminal-
Mr. Bora?
No,
but
they
they
have not received any summons.
Charge sheet was issued.
No summons has been expected.
charge sheet they have not exhibited.
We have.
FIR, FIR,
Exhibit.
put
7.
7 to money, oh, that's money.
Okay. Anything else?
And that
That
is
is-
why it is not even either the opening vehicle or the insurance of the opening vehicle or from the fourth vehicle, not from both. That is why has to make the party. If they discuss is subject there. That is we don't know. So you get the money either of the company, either of the vehicle, either from this he has already received. And that is the fact that the opening vehicle liability, it is a knock and knock agreement. Yes, as the case, in the offending vehicle and claim for compensation for damage vehicle. But on the one hand, he is claiming compensation from the offending vehicle. The other hand, the company received from his own company. So that cannot be entitled, but I have submitted. Same case.
Lordship, in this case, we had got full pay, so no amount was deposited, but 25,000 that was statutory deposit, we may be allowed. And Lordship, lastly, my humble submission will be to allow our appeal, Lordship, and dismiss the appeal filed by the claim.
It is number 9.
What is this knock for knock?
Knock either as a condition, either from the offending vehicle or from it.
They have
They
the
can
option, it is a
option, it is an
option, Lordship, that option the party can, Lordship correctly ask them whether they file it, and if they are aggrieved, they can go for an impact consumer case if they are not, but they cannot claim for the same thing twice. Lordship. Knock and knock is from one insurance or the other insurance, if two insurance are.
Okay.
It must
Okay. Hard, so. Hearing is concluded, judgment is reserved.
Highly obliged, Lordship.
Lordship, I just have a full submission, Lordship. There was no suppression on the part of the claimant as such. His understanding was on the lines of the, maybe he misunderstood or maybe he understood more than actually what petitioner didn't say. Or Sebastian.
It is not a question for parties to, Lordship, say that this judgment says that this, they should mention what is there. That is what is called coming before the court with clean hands. To get the money, and after 1 year, more than 1 year, you again file a case against somebody, and then you do not disclose that you have already got.
Okay, we'll consider.
Highly obliged.
Nala.
Eight. No. Huh? Oh.
Any urgent matters? No, I think, yes, Mr. Das? 11. When? 11. When do you want? 11, he'll give a date of your convenience. Here for the appellant. Other side,
I am for that.
what is the matter?
My lord, the injunction, ad interim injunction was used. There the plaintiff were against that matter, this active has been filed. And there is an order dated 18/1/2022 that the status to be maintained and the proceeding before the trial court that will continue.
Okay,
And that was continued to my instruction. We have filed our objection. But because of this status order, the learned trial court could not pass final order that is.
if status quo is granted by this court, we can remand the matter,
Yes,
Mr. Das.
that can be
Let
remanded
it be decided
by this trial court.
till such decision, status quo order will
The
be.
time frame may be given.
Yes.
So the objection
No,
was-
it's already late.
That
It's expeditious.
is here.
Hmm?
That is the problem. So the no effective order is here passed by the Learned
Hmm.
Court.
No, what Mr. Hawk is saying that it ultimately amounts to passing of an injunction
Yes.
by the status quo.
Status.
And since this court has not expressed any final opinion, let the matter be remanded back.
To the court.
You said ad interim injunction was not granted.
Not done. Yes, and
But
again,
the interim prayer is still there.
here, there is
No.
no-
Ad interim was not granted.
not
The-
granted, then they plenty filed this appeal before this court.
No, the prayer for injunction as such is still there open.
Yes, open. That was
Ad
not filed.
interim is what? Even before issuance of notice, you
Yes.
pass an interim. Not granted, you come before an appellate court. Appellate court has given you status
Status.
quo. It's almost an ad interim order. Now the learned trial court will decide the injunction application in
In the
accordance with.
meantime, they are disturbing our position. Difficult. That is why I am.
No, all these issues will be decided.
That can-
That is your prayer for injunction.
Yes.
Only the decline was only on the aspect of ad interim. The prayer for interim injunction would be, prayer for injunction would be decided in accordance with law.
Lordship may kindly fix the date so that
Tomorrow, can you do it? Will-
Can you please stay after-
Tomorrow, 2 o'clock?
can you stay after-
day after tomorrow may not reach the matter. Lots of matter will come.
The day after tomorrow would be it.
Day after.
On request, less day after tomorrow.
Okay.
Okay.
Lordship, item,
We'll pass in small order. We'll
Fine.
send it back.
Lordship, item 13, there is a connected the ad interim injunction is there to continue.
our matter
Is it limited by time?
No.
It's not limited by time. So why do you want continuation? We'll have a date fixed.
Okay,
Our,
what did,
Mr. Sankhya, you are for the other side.
yes, my lord,
Have a
our
date,
was
have
same, my lord, earlier, like alternate.
Uh,
At
What
interim not granted, that is why they come.
Now
Yes, it
status
will.
quo is there.
Yes, my lord.
We can have both the matters day after
Yes, my lord.
tomorrow.
Yes, my
We'll
lord.
remand it back.
Remanded the
Okay.
land
It will-
trial court with
Huh?
heard the matter, my lord.
Okay, 13. On request, least day after.
like,